Good. I see the main faces are present, so it's 11:45 near as can be said. So I will resume the inquiry and ask Miss Murphy to continue her cross-examination of Mr. Derbyshire.
Thank you, sir. Now, Mr. Derbyshire, just want to remind you, you perhaps don't need to be reminded of it, but that the council's evidence was expressly based on an assumption, wasn't it, about the appeal scheme, the stamp scheme constituting a fallback. You know that, don't you?
I'm not clear on that, because Mr. Connell's proof, for example.
Yeah.
So Mr. Connell's proof, sir, at 2.6. So this is his proof, not his rebuttal.
Yeah.
I've got the document.
Thank you, sir. It is noted the implementation of the extant permission was in early 2011, approximately 11 to 12 years ago. In this connection, I accept there is a theoretical fallback, although I'd argue, given the passage of time, the likelihood that the extent scheme would be delivered if the appeal is dismissed is doubtful. So your planning witness, in his proof of evidence, is taking a different approach, it seems to me.
You asked that we look at his main proof, not his rebuttal. His rebuttal goes further, doesn't it? I mean, we can turn to it if you wish, if it helps you.
No, his rebuttal does.
Yes, his rebuttal does. And also importantly, his rebuttal does, and just we don't need to turn to it, we can if you want, but the reference is paragraph 2 of that, so that can be noted. But the proof that I do want you to go to, actually, please, is that of Mr. Griffiths.
Yeah.
And Mr. Griffiths's proof, CD 10.2.
I have it, yeah.
Not 10, yes, 10.2, sorry, you've got Mr. Griffiths's proof.
I have it electronically.
Thank you. His page 6, which is electronically page 10. Paragraph 2.5.
Yeah, bear with me.
Yeah.
I have it. Yeah, I have it, Miss Murphy.
So he's explaining, isn't he, that the basis on which he's proceeding is that it's on an express assumption. It's assumed for the purpose, like the committee report. It's just, and the concept, and we've seen that and historic evidence on. It's assumed for the purpose of the proof of evidence to be a fallback position and given full weight as such.
Sorry, I was on 2.5.
Yeah.
Yeah, sorry. The impact of the appeal scheme on the significance of affected heritage will be gauged in this proof against the existing baseline and with reference to the extant consent.
The latter has been partially implemented, Botanic House, and assumed for the purpose of this proof of evidence to be a fallback position and given full weight as such. Now that's consistent, isn't it, with the approach which had been taken in the committee report?
I'm not sure that is. I'm not sure that is. Mr. Griffiths, I can't answer for Mr. Griffiths. He clearly says that, and he has given the fallback position, given full weight to it.
Yes, because in much the same way as the committee report did, it treated it as a fallback against which the appeal scheme could and should be compared.
I've dealt with it, and I think the committee report in the section that you do, it identifies it as a material consideration. I do not deal with it in my evidence.
Now, if you had received Mr. Bainbridge's email setting out the developer's intention. So you know that there's a theoretical fallback, and then you've got confirmation of the developer's intention. Then why would it be appropriate for the council to do anything other than treat it as a realistic fallback? Why shouldn't we just take Mr. Bainbridge's word for it, given that he's the appellant's agent?
There's other documents, Miss Murphy, the statement of common ground at 713, where where rather than relying on email in an exchange on a variety of other matters, there is an email that says 713 in the statement of common ground. It is agreed that the extant planning permission is a material consideration in the determination of the appeal.
Well, if you'll forgive me, that's not between us. We both agree that it's a material consideration, but the question is whether one goes further and treats it as a fallback or not.
Yeah, well, but surely the council's position would have been expressed in a statement of common ground rather than relying on an email from a colleague of mine in an exchange in a completely different context.
It wasn't a completely different context. It was about whether or not what the developer would do in the absence of planning permission vis-a-vis the flying pig, an element of the scheme. So it was entirely in open correspondence relevant to the developer's intention. Now, just want to understand from you, if Mr. Bainbridge's email, as you've agreed, was on instruction, when did the developer's intention change? Was it since November 2021?
The intention hasn't changed, Ms. Murphy. I've tried to be, I know it's not the answer that you want, but I've tried to be as clear as I can in my answer that there is a possibility that the scheme could be implemented, but that is different, and I'm placing different emphasis on the phrase would. I'm not saying would. I am saying very clearly that the scheme could be implemented, and I qualified that in my evidence in chief as to why I take that approach. And more importantly, my evidence very clearly sets out and follows from that approach that I deal with the baseline position. I compare the scheme against the development plan, the other material considerations, and then, as is consistent with the statement of common ground, I look at the extant scheme as a material consideration, because I think it is useful, because no committee report wouldn't say that this is a better scheme, bearing in mind the duty under section 72, which is to enhance, it's not just preserve, it's enhance the conservation area. So where there is an opportunity under section 72 to enhance the conservation area, which is a significant legal obligation, then why wouldn't an authority say, here is an opportunity to enhance the conservation area?
So let's then turn to the subject of opportunity cost. And within your evidence, please turn to page 39.
Yeah, I'm there.
Thank you. And you at 8.6 say, I'm not clear on what this means, as it's a binary proposition. And I think we've been around the houses on why a binary position is being evaluated, i.e. the extant scheme versus the appeal scheme. But if one were to assume that the appeal scheme was a fallback, properly understood, then there is a loss, isn't there, of the opportunity to have 156 units of housing, of which 63 would be affordable. That is right, isn't it?
It is a theoretical loss of 156 houses on the site. The point that I raised in chief is council have not included it in their projections. So
I know that, but the reason that they've not included it in their projections is not, this isn't some reflection on whether or not housing is needed or not. It is simply as a result of what they've been told by the developer, and they understand that the developer is pursuing an appeal which doesn't include residential. They couldn't do other otherwise, could they, and exclude it from the trajectory on that basis?
Well, that's not correct, because they took the same approach within the planning committee report. So the planning committee report wasn't subject to an appeal. The planning committee report, which clearly references the trajectory, was before the appeal, and it clearly says we haven't included. So it wasn't to do with the appeal.
Well, the fact is, if the developer is promoting a scheme which does not include housing, of course, the site is not going to be included in the trajectory.
Correct.
Correct. Right. So that the distinction you're drawing is one which doesn't lead to any actual difference, does it?
The binary proposition that I put in there, I accept your fallback position that there would be 156, but the point that I was raising here was in the context of a site allocation that you rely on that specifies no amount of housing. You rely on an extent planning permission that isn't in the trajectory, but because it was not clear from your evidence what when you said when in your statement of case that there was an opportunity cost. I didn't understand what that loss was. You're now telling me it's the 150. At the time I wrote this, the case you're now saying is it's the extant planning permission as a fallback position, which is 156. And I accept that if the fallback position was the inspector, it would lose 156
well, the
units on the
inspector
site.
has that, I think, difference between it. Okay, just then, we're now going to look at the extant scheme together. And in order to do that, we need the 7 series in the core documents group. And in that, we have got just the application boundary plan, which is helpful to look at. And that is CD 7.25. CD 7.25.
Yeah. Takes a little bit longer to load this one, doesn't it? But yeah.
All these drawings take a bit longer to load than the documents, don't they?
Yeah, I have it in front of me.
Okay, and what I've done is to sort of make sense of it is to turn, if yours came up landscape, I've turned the view so that it's portrait. I don't know if that helps you or not.
Okay.
You go into view, click view, and then rotate view just clockwise. Then you can then see what the text is saying on it. You may not need it, but I found that helpful.
So I can see the site.
Yeah, and what we can, it's a helpful reminder, I think, of the buildings which are included in the extant scheme, the area of land included in the extant scheme, and the buildings which are excluded. And so we can see that Ortona House and Francis House, of course, car park building, are all excluded.
Yeah.
Yeah. Now, in Professor Taverner's evidence, he indicated that in the consented scheme, Ortona House would be retained and Francis House would be refurbished. Do you remember that?
Say the question again.
In Professor Taverner's evidence, his written evidence, he said that in the consented scheme, Ortona House would be retained, Francis House would be refurbished, and the car park building would be retained. Just for your note, that's his main proof of evidence, paragraph 2.7. You can go there if you want to, but that's what he said. Now, questions to you. For question 1, is it right that Ortona House had at one time been considered as a location to which the Flying Pig could be relocated, whether permanently or temporarily?
I believe it was. I believe there was a discussion about it.
Okay. And then second question then, is it appropriate to assume that if the extant scheme were to be built out now, it would have to be built out in a manner which meets current building regulations requirements?
We would have to go through an exercise where it would have to meet building regs. Yeah. I'm pretty sure. Yeah. I'm not a building control inspector. No, I would put the challenge as well.
Okay, so then go back into your written evidence then, and your page 36, please, your main proof. Well, your only proof, of course. You didn't rebut what the council had said. Page 36.
I have it.
Thank you. And then you perform a comparison. I just want to ask you about I'm just looking for my reference. Forgive me, I'm just going to take a beat to do that.
No, that's fine.
Perhaps it's not here. Perhaps it's in the planning statement. Can I just understand? Do you stand by one of the comparisons that's been drawn, which is that the residential use within the extant scheme would be a worse neighbour to the Botanic Garden than an office use? Do you stand by that or not?
Just in the context of the Botanic Gardens as a neighbour.
Yes, indeed. Yeah.
I have some wider views on residential, but I definitely think it would. I think that active balconies overlooking the tranquility, peace, and calm of the Botanic Gardens would be an intrusion.
I see. Now that point, obviously, we contest. But I think that within your evidence a little earlier on, I think this is the reference I've been. You look at your 3.27 on page 8. It was established through discussions that the development of a commercial office-led scheme was considered to have a lesser potential impact on the Botanic Garden than a residential proposal. And you say that was important. Now, would you accept from me, or do we have to go and check it out together? Would you accept from me that the letter from them, the CD 3.10 letter from them, does not in fact make that point?
Yeah, I think it does make that point.
That's fine. It's in the 3 series, 3.1. This is the Cambridge University representation dealing with the.
Sorry, the university. You're talking about the university rather than the Historic England now. Sorry, Miss Murphy. You're talking about the university rather than the Historic England at this point?
Indeed, I am, because that's what you're talking about in your.
Sorry, I was bouncing down from the Historic England reference to new reference. Yeah.
Let's be clear. Your paragraph 3.27 is there talking about the position of Cambridge University Botanic Garden, and your point there is that an important factor was that residential scheme would have a greater impact on the potential than on the Botanic Garden.
Yeah.
Now, that's not reflected in the letter that we have from them at CD 3.10. That's the point that I'm on.
Yeah.
Okay, and so we can turn up that letter.
Yeah.
And it is just worth absorbing the key points that they're making. If you look at the second page of the letter at the top.
Bear with me, it's just loaded. 1 second.
That's okay.
Yeah. Second page.
Yeah.
Yeah, I'm there.
And so they agree, as the applicant had stated in the submission, that the University and Botanic Garden team have been invited to review elements of the proposals at a number of stages.
Yeah.
That they were reflecting on the process that had been undertaken. And then in the next paragraph, they say, well, we've now had the chance to review the full suite of application documents and offer our comments below where we wish to draw the attention of officers to particular areas of focus. So what this is saying is, all that's gone by has gone by. These are now our points that we want taken into account by officers. Now that's the sense, isn't it? The real sense of what that paragraph is saying.
Yeah.
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 And then can you help me with where then, I mean, are you saying that they make this point that you do about commercial development having a lesser impact on the Botanic Garden? Are you saying that they have said that in this letter?
They're not saying it in this letter.
They're not.
They've certainly expressed this to us verbally, and I believe there is an email that, because they are a sensitive partner and they are acutely aware of representations. I believe there is an email now that says that. It is not in the inquiry documents, but because of the timing of it after, but I believe there is an email in existence that confirms that.
Well, this, I can't go on what's been generated later and that I haven't seen. This letter does seem to have been intended to be their final word on the subject.
We continue to have discussions with them as we have a very close relationship with Botanic Gardens. We are a neighbour of them. We have met with Beverly Clough, the director, Michael Osborne, on several occasions. This is again an iterative process. That was the point they were prepared to write at this time. They are now prepared to confirm in an email exchange with my client that they prefer the commercial use. I believe that's my understanding.
It can't have been an important point for them when they wrote their letter, because if it had been an important point, they would have put it in there.
It was a sensitive point for them to raise, right. And they have to consider it. If you know the university like I do, it is quite labyrinthic. It is very old-fashioned in the way that it operates, Miss Murphy.
Well, I'm sorry, but that's not an answer to the point. If it was it's significant, if it was an important issue that they wanted officers to take account of, I put it to you that they would have included it in their letter.
I agree with that, but my point is the discussion with our neighbours didn't stop there.
Oh. Now, can I just also see if we can agree some of the facts? As I've understood the way the Botanic Garden operates, they close at 4 o'clock in the winter and they close at 6 o'clock p.m. 4 o'clock p.m. in the winter, and they close at 6 o'clock p.m. in the summer to visitors. Now, are you able to agree that with me?
I'm not aware of the opening hours.
Not aware of the opening hours. Right. And so just assume I'm right about that. It can't be that there's some disturbance as a result of using the balconies in the evening to visitors of the Botanic Garden if the Botanic Garden is at that time closed, can it?
It would, if there was no visitors to the Botanic Gardens, would there be harm to the Botanic Gardens themselves as an entity? Any harm would be severely mitigated by those opening hours, Miss Murphy.
Indeed. And what I want to just also understand is, what is the actual issue with balconies? I mean, if one thinks about potential issues, you've got, well, I suppose potentially noise and disturbance might be one, but I'm struggling to see the difference between a large roof terrace, work parties on roof terraces, drinks and so on. I mean, the whole intention is for them to be social, versus small residential balconies. I mean, really, that's got to be a zero-sum comparison, hasn't it?
The building would be very carefully managed. I deal with a lot of commercial buildings, so you wouldn't have the paraphernalia of individual bicycles, people putting up their matting to give themselves a little bit of privacy. The whole paraphernalia, that elevation would be, and we've seen it in flats. You've seen it in flats, what happens. It is very different to the structured setback of an office building, very different.
So what it comes to, really, I put to you that there's no real difference in terms of roof terraces and balconies on noise, in terms of noise.
Oh, no, sorry. You didn't say noise. In terms of noise, the balconies are further away. The roof terraces are much further away.
Well, all right, you're not leading any technical noise evidence. It does seem to me to be a pretty zero-sum comparison. You evidently disagree. We'll leave that one to the inspector. But really, when it came down to it, what you were really then saying is it's about the paraphernalia residential paraphernalia. And so are you saying that the visual change brought by some paraphernalia within residential balconies would have a significantly harmful effect on the Botanic Garden?
What I'm saying, it is a less desirable scenario than a controlled office building that has a sleek, uncompromised, undulating elevation to the park. It is, and it's. You're referring to the university here, but of course, the contextual position is historic England's position as well.
Can I just ask you this about residential paraphernalia? I'm not sure that featured, but can I just understand from you, so it's your professional judgment, is it, that residential paraphernalia on the balconies in the extant scheme would have a material visual impact on the Botanic Garden? Is that your position?
No. What I'm saying is,
sorry, yes or no?
No, yes, that I'm not saying that.
Not saying it would have any material visual effect.
It would have some material effect. It must do.
You think that the paraphernalia would have a material visual effect?
Yes.
And would that be in just close range views, or would that be from important places like Corey Lodge, for example?
I haven't done the assessment.
Haven't done the assessment. Right.
It is.
Or you know the Botanic Garden. Are you saying that you think from Rose Garden, for example, that you'd be able to appreciate that and it would undermine your ability to appreciate the significance of the Botanic Garden, as an example?
Contextually, it is a less desirable relationship than a sleek commercial building. That's the point I'm making, especially.
No, can I just understand, though, the answer to my question? Are you saying that from viewpoints such as from the Rose Garden, that being able to perceive their residential paraphernalia would undermine your ability to appreciate the significance of...
Not significantly. No, I'm not saying that.
Not saying that. So what about closer viewpoints? From the...
There will be noise. There will be noise disturbance. There will be activity.
I'm asking you about visual effect.
It will be very limited.
Very limited, even from close range views. Is that right?
There will be some impact. There'll be some impact, Ms. Murphy.
And would that be an impact on significance or just an impact, visual impact?
It's a visual impact.
I see. So no impact at all on significance of the heritage asset?
Well, Historic England thinks so.
Well, what do you think? I'm asking you about what your view is. Your
contextually, the office building is preferable.
Are you saying that there would be an impact, material impact on significance as a result of the residential paraphernalia or not?
I haven't been asked to assess this, so you're asking me a question, which is fine. In terms of the significance, no. In terms of the impact on significance of the conservation area, and I'm not a heritage.
No, I'll ask you about the Botanic Garden.
Sorry, on the Botanic Gardens. No, and if there was any at all, it would be fairly minor. It was a contextual position.
So let me be, so you're saying that there is or there isn't a material impact insofar as the visual amenity of the Botanic Garden is concerned?
There will, in terms of the context, there will be some noise. And in answer to your question, I think there will be some minor level, low level impact from visual amenity.
I see. So that's how sensitive you think the Botanic Garden is to changes from development in its context. That's very helpful, thank you. Okay, we're going to then turn to the application material that we have available to us. And turn, if you will please, to the planning statement. Once again, that is CD paragraph, CD 1.2. CD 1.2.
I still have it.
Good. And I think from your written evidence that you are saying that Bidwell's has been involved in providing advice on the scheme since about 2019. Is that right? Or have I misunderstood that?
It's slightly earlier, but round about there, yeah.
2018, was it?
Yeah.
Right. And did you write or review the planning statement?
I wasn't involved in the planning application. It was another partner that was involved at the time.
Another partner, but a senior person at Bidwell's was responsible for it.
No, I'm the senior person in Bidwell's. There was another partner in Bidwell's that
Right.
would have been involved.
And is it fair to describe them as the senior person at Bidwell's?
We have a QA process, a quality assurance process.
Yeah.
So the report doesn't have to be, as long as it is a partner that signs off the report, that is fine.
Right, but are you saying that you can have a partner at Bidwell's who's not particularly senior there?
We have 3 levels of partners, actually. So we have junior partners, equity partners, and then full equity partners like myself. No,
Okay.
A partner is a partner. A partner has responsibility in the firm.
Okay, and so was it a senior person at Bidwell's, or was it a fairly junior person at Bidwell's?
No, it was a partner. It was a former colleague of mine, Paul Wilmot.
Okay. And in terms of who was engaging on behalf of the developer client, it's senior representation, I think, at Bidwell's, and I'm assuming on the basis only of client instructions, just judging from what you say in your proof. Page, if you need the reference, page 6, para 317. So people who were conducting engagement was senior representation at not partner level, but assistant director level.
Yeah, but
Yeah.
I'm sorry, Ms. Murphy, that is assistant director at the City Council.
Oh, forgive me, I have misread that then, thank you. That's a helpful clarification. So
these meetings were conducted with the senior representatives at assistant director level.
I see. So sorry, I got the wrong end of the stick. My understanding was that you were saying there that the people who were conducting the engagement from your end were senior, but actually it's the people at the council who were senior. I see. So who was undertaking the engagement from Bidwell's?
It would have been Mr. Bainbridge.
Mr. Bainbridge.
And Mr. Wilmot. I don't know who attended those meetings.
Okay, and so just before I ask you any more about the planning statement, can I just understand from you whether or not you stand by its content or whether you think it requires correction or amendment?
Any planning statement, a planning statement is written at the time, the scheme evolved, changes were made, and so the planning statement was written at a certain time. I've written my evidence in light of the reasons for refusal and other things. So I cannot stand by this statement in its entirety because I didn't draft it and I didn't assure it.
If you don't stand by parts of the planning statement, which bits do you think you can no longer, the inspector can no longer rely on?
I would have to go through the document, Miss Murphy. That's not a question.
Are you prepared to do that? Are you prepared to identify whether now or at some other time before the close of the inquiry, the bits of the planning statement you think the inspector can no longer rely on?
If the inspector felt that was useful, sir, it's an exercise that we could undertake. I'd have to look at, but I'm not writing the planning statement. My evidence is my evidence that you have in front of you, sir.
Well,
but it's you asked me a question, Ms. Murphy. If you felt it was necessary, I haven't reviewed this in that detail. I haven't gone through that planning statement line by line because I was dealing with a reason for refusal.
It's quite helpful to know if there's parts of the application documents which you think are no longer reliable for one reason.
I didn't say that.
Say so.
I didn't say that, Miss Murphy. I said I haven't reviewed it in that level of detail. That's what I said.
But so you're not saying that there are parts of it that are no longer reliable?
Well, the scheme changed. So in relation to the flying pig and other matters, amendments were made to the scheme. So it would change.
We're not talking across purposes here. The planning statement is dealing with the appeal scheme.
But it was an amended scheme, Mrs. Murphy. So the scheme was amended post the application. That's my point. The scheme was amended. So the scheme was drafted. So there were changes to the scheme. Yes.
Well, yes, but we know what the scope of those was, and they weren't the sort of amendments which would necessitate wholly different conclusions within the planning statement. We've got the addendum, and it lists out the alterations. They weren't significant changes affecting the planning conclusions, were they?
Well, they related to the pig. It was my CD 2.2 that lists out the changes.
Yeah.
But I need to be clear here. I've been brought along to give evidence, my evidence. I'm an expert witness here. I'm not defending the planning statement. I'm giving my evidence based on my interpretation of the development plan, on my interpretation. So the role of a witness is very clear, Ms. Murphy. I'm acting as a witness here. I'm not saying there's anything wrong, because the quality of our work, I would like to stand by it. But I haven't reviewed that report in the way that you said, in the detail that you've asked me to.
Well, I'll tell you what, I'll then go back to the bits which I like your help on. If and to the extent you think that the planning statement is on reflection unreliable in relation to those bits, then doubtless you'll tell me. We'll turn within the planning statement to page 47.
Electronic 47, Ms. Murphy. Did you hear that, Ms. Murphy?
Sorry?
Electronic 47.
Electronic 47, yeah, because I think you were using the electronic.
I am, yeah.
Yeah, so yeah.
Okay, I'm there, Newtown and Glisson Road Conservation Area.
Thank you, that's the right spot. And in that section, which is dealing with harm, do you have the subheading?
I do.
Yeah. Do you see that first paragraph, 9.150?
Yep.
So where there's harm to the significance designated an asset, clear and convincing justification is required. In this context, it's concluded that the proposed development would result in less than substantial harm in the context of 196. This position has been discussed and agreed with Historic England. Now, I have taken from that at the time the planning statement was agreed, that Bidwell's was prepared to agree harm at the level that Historic England had identified.
We did this in detail with Professor Taverner, didn't we? Well, my colleagues, I'm not sure of your question, because I'm reading the words in front of me. What are you asking me to answer?
I've said to you that my reading of this is that at the time Bidwell's wrote the planning statement, they were agreeing the harm that Historic England had identified. So in other words, they weren't saying in the planning statement, Historic England had got it wrong, they've overstated the level of harm arising. They were saying less than substantial, but I've understood this to mean that the position has been discussed and agreed with Historic England, that would mean at the moderate level, the medium level. Because that's what the conclusion that Historic England had reached. And this seems to be just saying, well, that's been agreed.
Yeah, it does say that. It does say that.
Okay. And so then if one just takes a step back from all of the detail then of all of this, the heritage matters, as you rightly say, I took Professor Taverner through the detail of the Bidwell's assessment, that being the scheme assessment until his written evidence. If one thinks, well, where are we now? Well, we've got Historic England saying there's less than substantial harm at a moderate level. Bidwell's heritage statement saying minor or moderate. I'm not quite sure why they don't downgrade it in some state, but minor, moderate to the Botanic Gardens and the conservation area, which led to an agreement with Historic England. Council's conservation area, less than substantial harm at a moderate level. Mr. Griffiths, less than substantial harm at a moderate level. So, and Bidwell seemed to be to me in this planning statement, I think you agreed, prepared to agree with Historic England's assessment rather than to quibble with it. All of that together just looks to me to have reached a considerable amount of consensus as to the heritage harm arising from the proposal, doesn't it?
Um, well, the harm is set out in the statement of common ground as to where the parties arrived. So clearly there are discussions, and this is a planning statement which is submitted from day one. The statement of common ground sets out what is agreed. So I can have the discussion on what was said at the time the application was submitted, but there were subsequent discussions, as you know, from the date of the letter.
I know that since when Professor Taverner came on board, that the matters then changed. But I'm not asking you about that. I'm not asking you about the statement of common ground. I'm not asking you about what came later. I'm asking you about this, that Historic England, Bidwell's, Council's Conservation Officer, and in fact, Mr. Griffiths, that there was actually a considerable amount of consensus, wasn't there, as to the heritage harm arising?
Well, at that time the application was discussed, there was, when you say consensus, I would need to break that down, Ms. Smith, because I'm not the heritage witness here. These are questions that could have been put to, and this planning statement obviously is just taking out the relevance of the heritage statement. But there are some minor differences. I'd have to go back, but I'm relying on the statement of common ground as to where the parties arrived at, not the planning statement.
Just assume, for the purpose of this next question,
yeah,
as at the time the application went in, the applicant, Bidwell's, everybody was quite happy to agree that there was less than substantial harm at a moderate level. Just assume that for the purpose of my question.
Yeah.
What then prompts, in the appeal context, you to change position and say, well, there's not now a less than substantial harm at a moderate level, but something much more slight than that, is Professor Taverner's conclusions, isn't it?
Correct.
Yeah. And he was not involved at an earlier stage in the project, which he himself prefers to be, right? Was he? He accepted that. And he said that, in fact.
He did. He made it very clear that he doesn't take instructions. He doesn't take instructions that he's not happy with. He made that very clear. And
he also said that he wasn't criticising Bidwell's work, was he? He was at pains to emphasise that he wasn't criticising the work that had gone before. That's right, isn't it?
This is quite a lengthy cross-examination. He was quite clear that he's one of 3 practices in London that can join and take a holistic view on harm. He's a chartered architect. My colleagues in the heritage team, they're not chartered architects. That is a very significant difference, which allows, which allowed Mr. Alford to put it in a slightly different prism and arrive at a different conclusion. But I'm not the heritage witness.
Forgive me, I'm not asking you as a heritage witness. What I'm trying to understand is why, as planners, Bidwell's was quite happy to agree the position with Historic England, and then matters then change on Professor Taverner's, because there's still an evaluative process to undertake as planners, providing advice to the inspector. We, Professor Taverner and I, at a moment of happy agreement, agreed that design should be considered in the round, and that the effect on the proposal on setting, thereby the significance of designated heritage assets, that's got to form part of the overall consideration of design. And he didn't, in fairness to him, he didn't disagree with any of that. So design's not a separate matter, and he accepted that Bidwell's had taken into account all of the relevant aspects of the project proposals in terms of their design. So what I want to understand from you, please, is the basis for you reporting and relying on Professor Taverner's evidence rather than work from your own team, please.
It is not unusual. It is not unusual in an appeal process to bring in third parties to give it their own evidence. That's not a criticism of my team, Ms. Murphy. It was just a decision that the client wanted to take. They wanted someone more senior, more experienced, and a fresh pair of eyes, and someone that would give a degree of independence to it as well, i.e. would add an additional expert view to the views expressed.
Thank you. I've noted all that you've said, and are those factors that you've just listed out, those are the basis on which you've accepted Professor Tavner's conclusion, are they? There's nothing else, no other factor that you've taken into account which makes you accept his rather than the Bidwell's assessment. Is that right?
That's correct. I've taken the appellant's the heritage witness for the appeal.
Yeah. Okay, and then similar point, if you'll forgive me, in terms of townscape, your own townscape visual impact assessment considered a variety of viewpoints, and bearing in mind the sensitivity of the site, recorded major adverse effects at a series of them from the very centre of the Botanic Garden as well as in the eastern half. And so I just want to understand from you whether you think that there was something Bidwell's left out that Professor Tavener has taken into account, which has led him to a different conclusion, or is it simply just that it's somebody else coming in and taking a different view?
It is very much that. It is a degree of independence, I think, in his evidence. And within the committee report, the Bidwell's work was commented on. Mr. Tavener come in. There's no nefarious purpose here. We wanted an experienced witness that was able to bring a degree of independence, and so to bring in the Mr. Wolfer's architecture.
And just one question on this. Thinking about independence, is when the Bidwell's heritage team provided the assessment they did and the Townscape Visual Impact people provided the assessment they did, are you saying that they were other than independent?
Not at all, absolutely not. You've seen the methodology. You've seen the methodology attached to the documents. Yeah,
thank you. All right, we're going to now look at the local plan policy, and then depending on how far we get to before lunch, then also the emerging policy, and thinking about the residential requirement as we would have it. And I understand there's a difference between us. But where I think there probably isn't a difference between us is approach, and you'll know and accept, I expect, that the interpretation of policy is a matter of law, isn't it? And its application is a matter of planning judgment.
Correct.
Yeah. And then let's see how far we can go with this. Stop me if you are going beyond what you're comfortable with. But that's not to say that statements of policy should be construed as if they were statutory or contractual provisions, although a development plan has got legal status and legal effect. It's not analogous, is it, in its nature or purpose to a statute or contract?
I'm not a lawyer, Ms. Murphy. Okay. I would not be able to answer that question.
That's fine. And so, but can we, as I say, I preface that with wanting you to respect the boundaries of your own expertise. The interpretation of relevant policies, though, just depends, doesn't it, on a sensible reading of the language used in them, in their context and altogether. That's what we do. Yeah. Excellent. Well, that's a perfectly sufficient basis on which to proceed. So the council's interpretation, then we go back, if we can bear it, to the committee report, which is CD 4.1. And in it, to paragraph 8.12, please. So electronic page 35, paragraph 8.12. So the council's
I have it, Ms. Murphy.
Council's interpretation of the site allocation policy, M44. You accept, I mean, you've said you've accepted it's an allocated site. You do accept, don't you, that M44 is a site allocation policy? Yeah, just checking. Okay, so the site allocation policy is for mixed use development, and then the paragraph goes on. Spend the time to read it if you need to, but the main variation to the proposals is where I'm reading from, just a bit further than halfway along that, is that the 156 residential dwellings are no longer proposed to form part of the redevelopment of the site, and therefore, in this respect, the application doesn't meet the requirement of the mix of land uses set out in the policy for Station Area West. And so I understand that to mean that the council's treating M44 within policy 21 as including a requirement to provide residential. So that's one, they are, aren't they, in that paragraph?
Yeah.
And then that is also clear if you look at 28.25. So that's on page 38 under the conclusion. 8.25 under the conclusion on page 38.
Sorry. I'm just reading. 8.25, the first half of it before it goes over the page. Where are you? Mine goes over 2 pages, 8.25.
Yeah, it's quite a long paragraph.
8.25, yeah.
Yeah. So, although there's an extant planning permission for residential use on part of the site and a policy requirement to include housing, then it goes on to then talk about supply of housing. And I know you've sought to emphasise that, but at the moment I'm just on interpretation to help the inspector with this point. So here too, the council's treating the residential use as a requirement. So in terms of interpretation, it's treating M44 as including a requirement, isn't it?
It is.
Yeah. Now, the planning statement does have an annex which deals with the application of policy. I'm slightly loath to go back to that yet again, but can I just understand from you, when you've read that, I'm assuming you've read the planning statement quite carefully, did you read it as accepting that there was a policy requirement or not?
I need to remind myself now, Miss Murphy. I've got the planning statement open. Did you want to?
Fine. It's the annex to it. It is page 67 of the, I think, electronic pages. Let me just double check that. There's a policy.
I see that.
You see the policy matrix, and I'm not sure it was wholly complete, but let's not embarrass anybody with that. 60.
I'm on 64 at the moment.
Yeah, page 64 of the hard copy, are you?
Well, it's the this is electronic copy.
Oh, okay, so page 67 is where you need to be, if you will, please.
Okay, yeah, so I am on 67.
Yeah, okay, and so then I'm sorry, I think I started my references at the beginning, but in fact where we need to go is policy 21 itself, so that's page 70. Sorry, the referencing is a little bit imperfect there.
You've probably got
page 70. Yeah, no, I wasn't quite sure whether what it was saying, so I wasn't sure how the point would land. So paragraph 20, policy 21. It seems to be suggesting, if you look at policy 21, do you see the green box is the sort of Bidwell's response?
Yeah.
And it says that the proposed development doesn't provide for residential floor space as. Now, on one view, that's accepting that there's some requirement and having to provide a justification for not meeting it. But is that your reading of it or not?
The proposed development does not provide for residential floor space as there is extensive provision elsewhere in the legislation. I think that could be read of, that in the context of 21, that could be read of as there was a requirement to provide it.
It could be read, well, that's fair, thank you. Or it could, there's another reading, which is probably not, which I think probably doesn't take us one way further. But we could look under the bonnet of the whole, the point anyway, and I think that's really what we should do. So if you look at, if you take up the proposals map, and that's CD 5.2, the proposals map, policies map. I'll take a minute to load, I should think.
I've got a hard copy.
Oh, better.
I have to say, so when it comes to plans, I'm not very good on the screen. The one really good thing about the electronic is you can zoom in on it, and that's let me do that.
So I suppose what I'm wanting to agree with you is three things on the proposals map: that our site, the M44 site, it's got a number of applicable policy layers. And they are as follows. We've got the jagged purple edging, sort of triangular edging of the area of major change. Yeah. And then secondly, we've got this orange, kind of brownie coloured hatching of the opportunity area. If you just check down to the key there, brown, is it? Maybe light brown. And then we've got a purple colour of a proposal site, which is the site allocation that we've agreed. Yeah. All right. So we know that there are these three overlapping policy designations. And then when you go into the local plan itself, and within it, to policy 21, and I want you to go, please, the electronic page 88, or it's page 81 in the hard copy, which should bring you to the policy 21 station areas west, etc.
I have it. I'm there. I'm in the paper copy.
I'm just wondering if I think we'll just wind back up a bit, because there's an overarching policy for the area of major change, and it is, I think, we're just worth going there. I'm just going to take a beat to get my reference on that. Yeah. So you need page 64, please, electronic page 64, and hard copy page 57.
Areas of major change.
That's it. And so there are extensive areas of development comprising defined and known sites collectively shaping the spatial structure of Cambridge. So obviously there are important areas in an area, obviously finite, areas where you can achieve the development needed in Cambridge over the planned period. And the areas of major change are listed, and of course ours is that penultimate bullet point, station areas west. Yes? Yeah. And at 3.22, it then explains that the policies on these areas set out a planned approach to the areas of major change, and they include both general and site-specific requirements.
Yeah, it includes both. It does.
So it's setting that you've got two things going on in these policies. You've got a general approach set, and then also site-specific requirements. And requirements are expressed in that way, in terms, requirements. Yeah.
It does say including both general and site-specific requirements.
Requirements, yeah. And so far as policy 14 is concerned, with its general principles, when we can read them all, not this very moment, but it will be required to be read. And at 3.24, just providing some explanation of Council's approach, then 3.24, so we're on page 66, electronic, 59 hard copy.
I've got it. The Council wishes to ensure are developed in the most appropriate way.
Underline all of this, taking account of the sustainability, mixed use and design objectives set out elsewhere in the plan. So what the Council is wanting to see for these areas includes mixed use development, doesn't it?
Yes.
Yeah. Okay, and then we go, I think, down to policy 21, which is page, forgive me, where we started, page 88, electronic, 81 hard copy.
I'm there.
You. And the development ought to support the continued and complete regeneration of a vibrant mixed-use area of the city. That's the overarching aim, isn't it? So in terms of general aims, that's the general aim. Yeah? That's the general requirement they're set out in Policy 21.
That's right.
And then in terms of site-specific requirements, we then have them set out in the for the various allocations. And we can see that the site is then, our site, M44, is then allocated for residential use, isn't it?
Well, yeah, it's this is probably where we will park. It refers under letter J to residential use.
Yeah.
It says the numbers go from A to O,
Yeah.
and J within the policy 21 in the context of 21, it's residential.
Yeah. And so when something is saying, when a policy is saying, in effect, what the policy is doing is allocating the site for B1A and B1B, it's allocating it for residential, and it's allocating it then for a mix of uses in those classes. And so when one looks at, well, what's the requirement here? It includes residential, and surely that's the natural, sensible meaning of the language used.
It's a subtle point, but the language, as I expressed in chief, is not a directive policy. So it's referring in 21, the uses will include. I don't see that as a mandatory requirement. It sets out what it wants to include within the area of major change. And my view of that is when you have regard to the size of the area of major change, and it's well over 40 acres, there is going to be some flex within that. They've expressed, I think, residential on the back of the extant planning permission. I think it's flowed through various plans, and I think that's the approach that the officers take in the committee report.
I'll just ask you a question about that. Did you actually check the local plan examination inspector's report before you made that point?
Yeah.
Did you? Because wasn't the site originally identified just for residential use?
It was,
add in employment.
It was, and the inspector amended the allocation to
include employment. Yes, it was originally, wasn't it, a residential allocation?
It has been residential for some time on the basis of the extant planning permission. And what the officers say in the committee report at 8:15, what they say, sir, is although the original extant planning permission intended for housing provided and policy is largely predicated on this, the policy was drafted in 2013 and planning permission was granted 13 years ago. So I think there's an understanding that the allocation has flowed off the back of the extant planning permission. And I think that's the understanding of the officers.
Oh, just let's test this. Do you see then I know we're all focused on J, but look at B1A and B1B. Now, if I were to come along with a B1C scheme, would you be saying, well, that's acceptable or not? In the terms of the policy itself?
So Clifton area, B1A, B1C.
No, you've got in
yeah.
It says, well, it'll include B1A, B1B.
Yeah.
So if I were to come along and say, well, my proposal has a mix of uses in A classes, residential use, and also B1C, would you be saying that that's consistent with the policy or inconsistent?
I would say it's not inconsistent with what Policy 21 is doing because it includes a mix of uses. I would accept that the policy, and this is why you have to be very careful about prescriptive policies with areas of major change. But on the reading, I wouldn't necessarily say an employment use. And looking at the supporting text, within 383, for example, it's quite helpful if you look at 383 in the context of Betjeman House, because it clearly helps us explain the background that with the employment-led development of Betjeman House. Now, Betjeman House is the extant consent site.
In other words, your view is that even though the allocation says B1A and B1B, B1C would not be inconsistent with 21. And your view is that although it says residential, not providing residential is not inconsistent with
it's because of the citywide nature of these policies. Because of the...
Forgive me though, this isn't citywide. M44 is a specific site allocation policy.
Policy 21 is a citywide. The areas of major change, it's self-evident in the words. They are citywide policies. They are pieces that fundamentally affect the structure of the city.
I do think that this is the difference between us, the nub of it really, because looking at your main proof, your page 25, your focus, page 6.23, 6.24, is very obviously looking at policy 21 language, whereas Mr. Connell's focus and the focus of my questions in cross-examination are on the site-specific policy M44. Yeah. Now, just question. If one's focus is on M44, do you accept that the appeal proposal is inconsistent with that? It says it will include residential. Your scheme doesn't include residential. Do you accept that's inconsistent with M44? Do
you mind if I don't think will include is as directive as you're suggesting, Ms. Murphy. I just don't think the language is as prescriptive as that.
Well, if I was to say to you, Mr. Derbyshire, do go ahead and write to the team, but you will include me on that email, won't you? That's me asking you to do something, isn't it? Will include. My expectation is that that's exactly what you're going to do.
I think I don't think it's a directive policy.
All right. Well, there's the difference between us. But if I'm right, as I think you were invited to consider, that there is a requirement for housing.
How much?
Certainly, that would not be, or is it? I mean, what has Bidwell's advised? My understanding from Mr. Alford was that he's never considered or been asked to consider the incorporation of housing within the scheme. And is that because of Bidwell's consistent advice has been that there's no requirement to do so?
My client wants a commercial scheme, would prefer a commercial scheme on the site. But when you go back to residential use, Miss Murphy, we have a residential flat above the Flying Pig. So there is a residential use on. What is the extent? It is very clear that 331 dwellings on CB1, M14, 550, but there isn't a number attached to the stationary list.
You can't claim that the ancillary accommodation above the complies with policy because there is no net change, is there? So that's not providing residential as part of the scheme, is it?
But if you take your prospect, would providing two houses, you would argue that providing two houses on the site, two new dwellings on the site would meet the requirements of that policy. So
can I just have an answer to my question rather than you answering a different question which you've posed yourself? Should I understand from the fact that Mr. Alford said he had never considered the inclusion of housing within the scheme, should I understand that that is because Bidwell's has consistently advised that there's no need to do so?
My advice has been, as set out in my proof, that the policy, the allocation, that the consent has flowed through Station Area West. That my view that and this is based on 17 years working in the area within CB1, the policy has been applied very flexibly by the local authority in the past. And when I look at CB1 and the uses that have come and gone, that were included that have gone, then the authority has been incredibly proactive and dynamic in the way they're interpreting policy.
But I've put that question twice, and on neither occasion have I had an answer. I'm going to put it a third time, and then I'm going to move on. and I'll just comment on the lack of answer if you don't give me one. Should I understand from the fact that Mr. Orford said he'd never considered including housing within the scheme, that it has been Bidwell, should I conclude from that it's been Bidwell's consistent advice throughout that there's no need to provide housing on the site to accord with recently adopted policy?
It's not, the advice would be that we feel the commercial weight, the benefits of the scheme would outweigh, if there was perceived to be a loss of residential, outweigh that.
Well, I've put that 3 times, that's not quite an answer, but I'm still going to move on. And if you're wrong about it, if there is a requirement and the scheme hasn't met that requirement, I mean, it's obviously not the only policy in the local plan, we'll come to some others, but it is a significant one for the scheme on this site, isn't it? It's a site allocation policy, of course it is.
In terms of the success of the appeal?
Well, it's a significant policy not to accord with, isn't it? Because it's the site allocation policy.
But I go back to my question. What is the extent of the residential use that's required in the policy? But
let me put the question for a second time. If there is conflict with this site allocations policy, that is a significant policy conflict for the scheme, isn't it?
No, I don't think it is a significant conflict.
Not significant.
It's not
Okay.
significant.
And so you'd contend, would you, that not complying with the site allocation policy for the particular site on which you're promoting development, you don't think that would be influential in terms of a conclusion about compliance with the development plan, or do you?
Well, the planning officer in the committee report described it as a technical breach. That was their phrase that they used in describing the lack of residential. Their words in the committee report was not significant. If you take their view, their words, and I will find the reference for you, but their words were that it was a technical breach. And I will. So when you're asking me, the local authority, when constructing their committee report, referred to a technical breach.
Where did they do that?
I will find it for you. Bear with me 1 second.
That'd be very helpful.
Sorry, it doesn't say technical breach.
No,
So, no, it's 828.
No, it doesn't.
No, it doesn't. No, I'd have accepted that. What it says, whilst there is some conflict with.
Yeah, I mean, what that's doing is saying that there's conflict with policy.
The question you phrased to me was significant.
Yeah, well, I'm asking you whether a conflict with the site-specific allocation in the plan for the site on which you're proposing development, whether that is influential in terms of conclusions about compliance with the development plan as a whole. Now, do you accept it would be influential or not?
You know, I think it is a consideration for the inspector. It is something that he has to take into account.
And it's a consideration. It's a significant one, isn't it?
But I don't think it is significant. Yeah, I answered that.
Thank you. Okay, well, I'm just about to move on to a different point. So, and I have still got probably. Well, let me just take a minute to work out how much longer, but certainly so more than would.
Yeah, I think it'd be a good idea to have lunch now for an hour.
Good.
We'll call it 1 p.m. now. It's not just before that. So I will adjourn for an hour and resume at 2 p.m.
Thank you.
Thank you, Stan.
Good afternoon. 2 p.m. I will resume the inquiry for this afternoon session. The last session that will be virtual, touch wood. Anyway, over to Miss Murphy to resume her cross-examination of Mr. Derbyshire.
Thank you, sir. And good afternoon to you, Mr. Derbyshire.
Good afternoon.
Is it your case, Mr. Derbyshire, that the local plan of 2018 is out of date?
No.
So it's an up-to-date local plan?
Yes.
Yeah. Thank you. And it was found sound, wasn't it, at a recent examination, including in terms of its provisions for for jobs and homes.
It was.
Yeah. And it's a matter of record, I think, but maybe we can agree that the appellant didn't object to the local plan policy for the site M44.
Yeah, it was a different world. Although the plan was adopted in 2018, the inspector will be aware it was an extraordinarily protracted examination that took 3 to 4 years. So it was. So at the time, Ms. Murphy, the point I'm making, the market was quite different to the market it is today.
I see. Now, I just wanted to make sure that there hadn't been a sort of slip between us, but you were involved, weren't you, in that local plan examination?
Not on this scheme, no.
Not on this scheme, but you were aware of
and
you participated in the examination.
Yeah.
Yeah, and you, as you said in giving the evidence that you had looked at the inspector's report into it.
Yeah.
I think we agree, but I just wanted to check that the inspector did make particular mention of the designation of the Bitumen House R44 site for residential use, and that there was a modification, wasn't there, to newly include employment use.
Of course.
Yeah, okay, just wanted to check that we had agreed that. Okay, fine. Now, the housing need at that time, at the time the plan was adopted, was described as high across the city, wasn't it? Does that ring a bell for you? I can take you to the reference if you need it.
If you could, just for completeness, Ms. Murphy. Sorry, we've opened a lot of documents.
Don't have to take it from me. It's CD 5.1, which is the local plan itself, and at paragraph 1.12.
Thank you.
That's perfectly all right. That's page 12 of the electronic document, and it's page 5 of the hard copy. So 112. The need for housing in Cambridge is high.
Yeah, that's not unsurprising.
Sorry?
That's not unsurprising.
Of course, it's not a surprise. I mean, and that was at a time at which it was literally just been demonstrated that there was a sufficiency insofar as the 5-year housing on supply was concerned.
Yeah.
Yeah. And as far as affordable housing is concerned, well, this plan, like many others, even if every allocation was built out in accordance with its terms and affordable housing provided at target level, it still wouldn't meet the affordable housing need for the city. That's right, isn't it?
Yeah. Which is not uncommon for a lot of cities.
I'm not saying it's uncommon, but it is true here.
It is.
Yeah, and isn't there acute pressure for affordable housing in the city?
There is.
Yeah. Now, the early review of the local plan, which was promised and now is coming to fruition through the emerging plan, which we're just going to look at in a moment, that was not in order to deal with employment floor space, was it? That was primarily in order to address housing need.
You're picking up on Mr. Wise's comments, aren't you, in terms of his evidence?
Well, I'm actually about to go to the emerging. We'll go to the emerging plan in a few moments. But I mean, it itself. Oh, maybe we can pick that up. Why quibble about it? If you go to the CD 5.12 and CD 5.12, 5.12, the emerging proposals will be coming back. We'll be coming back to this in a moment. So if you could have it keep it to hand, that'd be useful.
Bear with me.
It's okay.
It is open.
Thank you. And within it, if you could turn to page 12 of the electronic pagination. And I don't know if anybody's working on hard copy. Happily, it's 12:30.
Yeah, I have it.
And so you'll see that an explanation is provided as far as the early review is concerned. It's a paragraph which starts with both councils. Do you see that?
Yeah.
They adopted their current local plans in 2018. These included a commitment to an early review, in particular to update the assessment of housing needs, to review the progress of delivering planned developments, including new settlements, and to consider the needs of caravan dwellers and government changes to the approach to planning for gypsies and travellers. Yeah. So what I put to you is right, isn't it? Primarily, I mean, it's not that it's not covering other matters like gypsies and travellers and so on, and looking at progress on monitoring, but primarily it was about the assessment of housing needs. Now that is right, isn't it?
Yeah, although representations were made by a number of parties about the inadequate provision of commercial floor space in the plan. No, in answer to your question,
The plan was adopted as it was, and the early review commitment related primarily to housing needs. Yes. Now, just then, in terms of the emerging policy position, I mean, I want to just look at your proof at page 37. If you're good enough to turn that up for me, and within it, under the heading, the emerging policy position, 7.41.
Yep.
You consider that preferred options document, forgive me, just let me, sorry, I don't know if I've lost you. Are you?
He's still there.
Okay, good. It's always a bit scary when the screen freezes for a second.
I've got a slightly fragile connection, but I've been okay so far. So.
Thank you very much indeed. Page 37 then, paragraph 7.41 of Mr. Derbyshire's evidence.
Okay.
And at 7.41, you're acknowledging that the emerging joint local plans at a very early stage, quite rightly, Regulation 18 should be given limited weight. So this is paragraph 7.41 on page 37.
Yeah, I've got it, Ms. Murphy.
Thank you. And then what you go on to say is that it provides useful background on the direction of travel locally. And indeed, the evidence base of the emerging policy position is particularly important. As up-to-date evidential work, I considered it should be given considerable weight. And you then, in that context of wanting considerable weight to be afforded to the emerging evidence base, you include the November 2020 Greater Cambridge Employment Land and Economic Development Evidence Study. Now that, may I just make sure that I've understood that that's the GL Hearn document, the CD 5.7 document, isn't it?
Correct.
Yeah. And so what, we will need to go to that, but I think what we can agree before doing so is that the up-to-date published material on which the council have relied for their emerging plan is not suggesting the release of land allocated to housing for employment use, is it?
Well, this is the travel of direction, Ms. Murphy. This
right, of course. I've prefaced the question perfectly properly. We were not in any disagreement about that, but the up-to-date material on which the council's relied for the emerging plan, it doesn't advise, does it, or suggest the release of land allocated to housing for employment use?
What it says, so if you could bear with me, I might need just to direct you to a couple of references.
Well, that's perfectly all right, provided you can give me a clear answer to my question before you do. It doesn't, does it, suggest releasing land allocated to housing for employment use?
I think it does.
Really? Do you want to take me to where it does say?
Yeah. So this is my reading. So at the bottom of page 31.
Yeah.
So tell me when you're there.
Bottom of page 31. Is that the electronic page number? Is it?
It is. Fortunately, they seem to be consistent with each other at the moment, don't they?
Was relief. So 31.
We also propose to promote flexibility to the amount and type of employment land supply to help.
I'm on page 31. Which paragraph are you asking me to look at?
Very last, beg your pardon, it's the very last paragraph.
On page 31?
Yeah. 5.1.
That's not what I've got.
Sorry. So can I just go back to a document? We're in 5.7. Beg your pardon.
The GL Hearn number.
Sorry, we've jumped to 5.7. Apologies. I was in a different document, Miss.
No, well, the GL Hearn.
I thought we were in a different document. I thought we were in 5.12. My apologies. So
No. It's quite all right. What I'm on is what advice has the local authority been given in the emerging evidence base, and the point I put to you, which I have to insist is correct. Yeah. The employment, the consultants are not suggesting the release of land allocated to housing for employment use. I mean, it may be more helpful, in fact, if I just take you to the conclusion section.
Please.
Okay, so we'll go then, if you go to page 114. This is the balance of floor space needs, and this is section 7, so page 114 of the document, drawing it all together.
Yeah.
Making recommendations on the balance of future floor space needs. And when you want to understand the sort of broad overview, the table that you look at, is table 41. Okay, demand supply by summarized use class. Yeah. And then in terms of the words, they're addressing B1B in particular, and then they're looking at the main components of B1 supply. They're at 7.5. And in terms of the recommendation, then they're saying at 7.6, there's still expected to be a shortfall in B1A/B provision under the higher scenario. And then what they say is GLRN recommends that further allocations are made to accommodate both office and wet dry lab needs in Greater Cambridge. And then they talk about the role and mix of North East Cambridge Action Plan in providing the growth of overspill function, which is, they say, essential. And then keep going.
Yeah.
And then I'll put the question to you. Keep going. Then under the heading offices. Yeah.
Yeah.
Good. As far as offices are concerned, it's a mixed market, highly locational within the submarkets. Take up outside Cambridge, including at Camborne, has proved to be a bit protracted. And then in parallel, the draw of the city centre and Cambridge Science Parks has proved relentless, with rents continuing to rise. And you see here, don't you, echoes of the WISE evidence, which is that in the, albeit acknowledged small, core or sub area, there's very high levels of demand.
Yes. Yeah.
And then the strong corporate office market demand going forwards for the Science Park, North East Cambridge. They're looking at the sustainability of the station, etc., etc. I mean, you do need to read it all. We can't obviously do that as part of the cross-examination process. You need to particularly read up to 713. And so, as set out both in the property market review, while there's a reasonable offer in terms of flexible and managed workspace, this remains in high demand to the degree it's considered to constrain business opportunity, and as a result, further intervention is recommended to improve the offer. So it's pretty clear advice.
You slow down just a little bit, Ms. Murphy. Where are you now? Which paragraph are you on?
713.
713.
Okay.
I'm reading it.
Yeah.
Yeah.
Now, so in other words, all of the sorts of pressures which your team had identified. I mean, I think we're clearly, in fairness, I think has been accepted earlier on by Mr. Brooke, were present earlier prior to the 2018 adoption of the plan. But all of those pressures are acknowledged in the GL Hearn report, aren't they? And in terms of what the city council is then doing, if we then turn to the emerging local plan, so the city council gets all the advice from GL Hearn, thank you very much indeed. Right, here are our first proposals. I mean, of course, it's not finished work, but the proof of the pudding in terms of what council's proposing, CD 5.12.
Yeah, I'm in there.
Brilliant. And what you'll see is that there is really quite a careful sort of they're quite selective in terms of what they do with particular allocations. So housing, for example, go to page 72. They give a careful explanation of why they're not proceeding with certain allocations. So, for example, on page 72, if you're there, CD 5.12, when you're there, let me know. Good. You've got housing. Do you see that at the top? Yeah. And then there are following residential allocations. And then underneath the series of green bullet points, you've then got the following residential allocations are not proposed to be carried forward for the reasons set out below. Do you have that?
I do.
Yeah. So there are particular sites where they're not proposing to maintain or to roll forward allocations, including housing allocations, and the paddocks at Cherry Hinton Road would be an example of that. Some really quite careful thinking going on there. Yes? As you'd expect.
Okay.
Yes?
I'm on unemployment E4 at the moment.
Okay. So you're with me so far. There's there's selectivity going on here. Council's evaluating the allocations from the previous local plan, and it's deciding whether or not to roll them forward and providing reasons for that. So then we come to this page, the allocations that they are proposing to roll forward, continuing existing allocations, page 70. So you should have a map of some other proposed allocation, but this one, the subheading, continuing existing allocations. Do you see that?
On page 70, I have map of proposed allocation S/C/SCL.
Yeah, so ignore that and focus on the subheading underneath it, which is continuing existing allocations.
Yeah.
Yeah.
So the following out will be included. Yeah.
So so where have we got to? Some allocations are not proposed to continue, and then some are. And we've got a series of housing allocations listed underneath that. And keep going. And then you've got mixed use allocations. Now you're now on page 71 of the continuing allocations, mixed use allocations.
Yeah.
And one of the mixed use allocations, which is intended to continue, is M44 Betchman House. Yes?
Yeah.
Good. And then on page 73, keep going, and then we're on electronic electronic page 73 and real page 73. Do you see that? You should have a heading in a big green heading. Why is this policy needed?
I'm on that.
Yeah. Previous local plans have allocated most opportunities for development within the urban area. So there are relatively few smaller scale development opportunities that have not previously been considered. And it explains all of that. And then, and again, we're not going to read every word of it, but if you look at the however, just read all that. and I'll put a point to you.
Yeah.
But the point here really is that there is a careful evaluation of the allocated sites and the justification for continuing to rolling those forward. And the proof of the pudding is, of course, that M44 in its current form is retained, isn't it?
As a mixed use.
Are you agreeing with me?
It is M44 is carried over as a mixed use.
Yes, it is carried over as a mixed use, isn't it?
It is.
And it is intended to be carried over in its existing form, isn't it?
If you could point me to that chapter, that would be helpful.
I'm sorry, I don't follow you.
Well, we are proposing a mixed use scheme. It just doesn't include residential. Mixed use isn't exclusively residential and employment. A mix of uses is mixed uses.
But I've literally just taken you to page 70, which explains that the allocations are proposed to be carried forward, i.e. the allocations contained in the 2018. Oh, hang on, I think we may be at cross purposes. If I am right about the interpretation of the 2018 local plan, and it does include a requirement for residential, then that too is what's intended to be carried forward, isn't it, in this emerging plan? Whereas if you're right and there's no such requirement for residential, then that's not, then in a sense it's not carried forward either. But if you like, whatever the intent, the purpose and intent of the effect of the M44 allocation in the 2018 local plan, that's intended to be carried forward, isn't it, in the emerging plan?
Yeah, but that 741 is unhelpful in terms of the way I've constructed it, and I apologise for that, sir. The plan should be given limited weight for the reasons I don't need to. Miss Murphy is absolutely right that I say that, but I said in the context of the direction of travel with the housing trajectory and also some of the comments around flexibility. And if you're happy, I can take you to that. Clearly, we wouldn't be supporting that, Ms. Murphy, because as you know, we've made objections to that policy in the sense that we've written into this local plan these proposals before Christmas, objecting and making it clear that our scheme is a commercially led mixed-use scheme. That is what we've said in our representations to this plan. So it would be very strange to me at this inquiry to be saying, that's fine, I support that, when just before Christmas I made an objection to it.
We're at slight cross purposes. Can we just take this in stages? We'll come to your objection in a moment, but just take it in one step at a time. If what I'll describe as my interpretation of local plan policy 2144 is right, and there's a requirement for residential, then that's intended to be carried forward into this emerging plan, isn't it?
It's hard to come to terms with that when we've looked at the housing trajectory. We've looked at the council themselves have said because of the uncertainty of the consent, we don't intend to allocate any housing on this site for the housing trajectory for 2030, up to 2031 and beyond.
Well, so hang on a minute. A housing trajectory is not an allocation. A housing trajectory is a reflection of what's likely to be delivered within the 5-year period. It's got to be based on what local authorities are told. I mean, it's not an allocation. Of course it's not. Now, hang on, my computer's going to go to sleep if I don't plug it in, so just give me a moment.
Just checking mine, actually.
As long as we don't go to sleep, that's the key. That's the key thing on a Friday afternoon after a nice lunch. All right, but in a sense, I think we probably get to the point at which we just make submissions on that, and that's fine. But I just want to just want to just one final point on it. Your objection to the emerging plan, the basis upon which you object is because you say, well, there shouldn't be a residential requirement for this site. Yes.
Correct.
Yeah. Thank you.
Can I, while we're in this document, sir, there's a couple of references that I'd like to draw your attention to.
Is it in response to my question?
It is, because it is in response to your question about the direction of travel that I refer to in 741. So this is directly responding, Miss Murphy, to the point I put in my evidence in 741. You pointed me in the direction. I'd like to explain why I've included reference to that.
Go for it.
Yeah, thank you. I referred to the direction of travel locally, sir, in that paragraph, and as you can see, the proposed policy direction is at the bottom of page 29.
Are you now talking about 29 in the emerging plan?
I am.
Right. So help me with what's the point here?
It also seeks, this is the last sentence on the bottom of the page, it also seeks to be realistic around the locational limits of some jobs floor space, which is centred around national and global economic clusters. That to me is understanding the importance that these clusters have. And on page 31, sir, at the bottom of the page again, we also propose to provide flexibility to the amount of time to help enable the greater.
Where are you reading from? Sorry, where are you reading from?
Apologies, it's the bottom of page 31.
Bottom of page 31, just a second now.
Of course, yeah.
I'd make such a terrible witness. Bottom of page 31. Okay, thank you.
We also propose to provide flexibility in the amount and type of employment land supply to help enable the greater Cambridge economy to flourish. Okay. And the final point I make, and thank you for bearing with me, is on page 39. We have evidence that locating homes close to existing jobs. This is a point about homes and jobs. The reference there, sir, is to the cluster of research parks to the south of Cambridge. It isn't within the town centre. That jobs work balance would help reduce commuting and associated carbon emissions. The advantage we have, sir, is that we are sat bang on top of a station. So we are trying to achieve exactly what the council is now seeking to remedy. This jobs homes balance is particularly acute in the southern cluster, and the council have recognised that's where they need to put their homes. So apologies for taking you there, sir, but I wanted to be clear why it's always a danger to refer to an emerging local plan, and it's a two-edged sword. But they were the references that I wanted to take from the document. Miss Murphy's taking you to hers.
Well, we're not quite finished yet, though, have we? Because each of those references, which should provide the inspector with considerable reassurance that the council has all of the important points in mind, those have all been taken into account, haven't they, in deciding whether or not to continue the allocation of site M44 in the way that they have?
Yes, which we've objected to.
Yes, which you've objected to. Now, if we go then to the framework, so the National Planning Policy Framework, and I'm assuming, I hope not rashly, that you've got access to it.
I have. It's not a core document, actually, because I think we're told by the inspector not
to And then we're all weeping if we don't. It's usually the PPG, actually. It's not usually the PEP framework that causes us problems. Anyway, then we'll have to scrabble around Googling it. But 122 of the framework is where I'd like to go.
Sorry.
Yeah.
I because I'm impaired, I turned my internet off for obvious reasons. Not want to disturb you with the noises that were coming from my.
So are we going to get lots of? Should we just brace for lots of pings while you turn your machine on?
No.
Okay. Paragraph 122 of the frameworks where I'd like you to land next, please.
Yeah.
So what's that telling us? Well, the planning policies and decisions need to reflect changes in demand for land. They should be informed by regular reviews by both the land allocated development and plans of land availability. And I think just judging by your 7.41, I mean, very fairly, I think what you're doing is you're commending the local authority for already having reviewed, having produced evidence to review its local plan, and that's the GL framework on which you're placing considerable weight. And the emerging policy then, having benefited from that review, says what it does. So it's entirely consistent, all of that entirely consistent with paragraph 122 of the framework, isn't it?
I think it works. It's the framework, and those two policies are correct. It's just that the reference in 741, I think, has been taken to an extreme in my part, in the sense that I have said that, but what I was looking at was the direction of travel rather than the evidence base, which has clearly been challenged, Ms. Murphy.
Well, I'm sorry to be taking you too literally, but you did say in your 7.4, when I say I'm sorry, probably not quite true. I mean, as up-to-date evidential work. I mean, you were talking there about the evidence-based evidential work. I consider it should be given considerable weight. I mean, that is a pretty clear conclusion. You then identify the GL Hearn work as part of the evidence base to which weight should be given. But whether or not that's true, if like whether or not that's overstated in your evidence, and if on reflection you think it's overstated, fair enough. But whether or not that's right, what we can agree is when you look at paragraph 122 of the framework, you and I can recognise that what the local plan has, the local plan process shows is that since 2018 and adoption, local plan has commissioned evidence, and the evidence has been taken into account, and the emerging plan shows the continuation of the allocation for this site. All of that entirely consistent with the process envisaged by paragraph 122 of the framework, isn't it? Yes. Okay. Now, may I then ask you then about the sort of conclusions which follow on the key inquiry issues in front of us, because there's a fork in the road here. There's a long way that we can go, quite happy to do, or there's a short way that we can go. Again, quite happy to do either. Should I take it that if the inspector were to accept the evidence of the council, Mr. Griffiths and co, and Ms. Reynolds and co, that there's harm arising in various ways, that there would, in consequence, be conflict with the development plan policies identified in the reasons for refusal? Or do I have to take you to the specific policy on that?
You're talking policy 62.
Well, I'm talking about the policies identified in the reason for refusal. Or should I take it that if harm is found in line, say, look, take Mr. Griffiths' evidence as a good example. If the inspector were to say to himself, well, I do actually accept that Mr. Griffiths is right and there's less than substantial harm at a moderate level, my conclusion is that that means that the development fails to preserve the significance of the heritage assets affected, and therefore there's a conflict with local plan policy. Now, do I understand from you that there's any dispute between us that that would be the sort of necessary and logical conclusion, or is there a dispute on say, particular wording of the policies?
Policy 61 states that to provide clear, and this is 642 of my proof, sir. If you can let me know when you're there.
Yeah.
Well, at the moment, what I'm trying to do is to work out which way down the road we're going to go, the short way or the long way.
Well, what I'm saying, I think you're going to take me on the longer journey, because what I'm saying in 642, 61 says, provide clear justification for works that would lead to harm or substantial harm, yet be of substantial benefit through detailed analysis and assets and of the asset in the proposal.
Yeah. Well, if one thinks about it in this way, if you've got, if you were going to accept Mr. Griffith's evidence in its entirety, there's a necessary, isn't there, conclusion that you would reach, which is that there's a breach of policy 61. Because those criteria within policy 61 are conjunctive. It's the semicolon and. So if one accepts Mr. Griffith's evidence, and this isn't just an example, you're going to say, well, does the proposal preserve or enhance the significance of the heritage asset of the city? Well, no, it doesn't, because it causes harm to significance.
I don't agree with that proposition, because in my proof on page 30, it's 6.7, I say, or 6.7.2, the balancing exercise under the MPPF 202 has been carried out through the prism of the development plan. As a consequence of my review against policy 61 Part E. So
what that's doing is mixing up your conclusion as to the policy with the actual question that I asked you. The question that I asked you is, if you were to accept Mr. Griffith's conclusions in their entirety, the necessary implication of that is that there's a conflict with policy. Conversely, if one accepts Professor Taverner's assessment, what you would say is that there is going to be a lesser degree of conflict.
I'm not sure the point that you're raising, actually, where an application would lead to harm or substantial harm to a non-designated asset. The approach we've taken is through the prism of the local plan. And if you go through that process, then the conclusion that I've arrived at is that it's compliant with the policy. Your question was, would the harm, as a matter of fact, then be contrary to the development plan?
No, I see why you're giving the answers that you are. So let's just pause and ensure that it's clearly put. My fault, not yours. Mr. Griffiths is identifying, isn't he, harm to significance of a range of heritage assets?
He is.
He is. And little a, just take that, a good example of policy 61, is asking that to ensure the conservation and enhancement of Cambridge's historic environment, proposals should preserve or enhance the significance of heritage assets of the city, their setting in the wider townscape, including views in and out. Now, if the inspector were to accept Mr. Griffith's evidence, he would have to conclude, wouldn't he, that there was a breach of that policy.
I think I've answered this question, Ms. Murphy, in the sense that...
Could you just have another go for me?
You're required to preserve or enhance the significance of the heritage assets of the city, their set in the wider townscape. But it clearly is an implicit to me that Part E provide clear justification for any works that would lead harm, i.e. the prism of 202. So my conclusion is set out in 670 is set out in 672.
Yeah. And isn't your conclusion in 672, isn't that all predicated on Professor Taverner's evaluation of harm?
No, because at 674, the City Council conclude that the level of harm is to the desert, as median Professor Taverner concludes the level of harm, even if the City Council assessment of the degree of harm is preferred by inspector. Bear with me, even if the City Council assessment of the degree of harm is preferred by the benefits which I've set out, in my view, clearly and significantly outweigh the level of harm.
Sorry, but that's a different point. I mean, this is the policy 61 is addressing itself, isn't it, to essentially preservation. And E is simply reflecting, isn't it, the part of the framework which necessitates clear and convincing justification. That's what that's saying. That's not about weighing up overall benefits versus harms, is it?
Well, I think it is, and that's what I say at 672.
No, this is much more specific than that. It's providing clear justification for any works that would lead to harm.
It says provide clear justification for any other types, and yet be of substantial public benefits.
Oh, I see. Well, the inspector doubtless has a difference between us on this. I'm afraid I think I am going to leave it to submissions about the sort of necessary implications of conflict with policy, and I think nonetheless, despite your answer, I think I'm going to go the short way. And so I am just going to ask you about the particular benefits that you rely on. Now, economic benefits. Nothing between us on that. Significant weight attaches to those. So good, tick, and welcome, of course. The social aspects of things are just a little bit of care. The council's position, as I think you've understood, is subject to the imposition of the necessary conditions on its case. In other words, a condition that you don't agree with. So it's not, there's no concern any longer, and that's the end of it. It's that the council's position is that subject to condition, the imposition of the necessary conditions, that need not concern us.
You're stating your position. I don't think there was a question there, Ms. Murphy.
I am actually, in I hope a reasonably, tolerably pleasant way, taking you to task, because the implication of your evidence in chief was that the council's no longer pursuing any, that the council no longer has any concern in relation to the flying pigs. Not quite right, is it? What the council has said, and it's recorded in the statement of common ground, the inspectors had a very useful, I hope, roundtable session on a discussion of conditions can continue, but the council's position is subject to the imposition of necessary conditions, isn't it?
That's what he said in chief. He said subject to the debate about conditions. It's exactly what he said in chief.
Okay, in which case there's no
dispute.
Oh, okay, good. And so then there is obviously a dispute between us about whether or not the public realm is as beneficial as as is claimed. But what we can, I hope, agree is that there is considerable and in some cases competing pressure on the public realm on the Hills Road side of the development.
I think that goes totally against what Policy 25 is trying to achieve. The opportunity area is explicit in identifying public realm improvements. And when you walk from the church, from Hills Road to the site, you will see why these public benefits are desperately needed. And that's why in Policy 25, which I think Mr. Kukowski actually referred to in cross-examination. Bear with me. This is the policy which deals with the opportunity area. So many tabs, you over tab, don't you? And the tabs become redundant because you've got too many.
I know, or isn't it?
So it's the adopted local plan
Page 103, electronic,
No.
96, hard copy.
96 hard copy. Yeah, and it's part D, create a more comfortable and simplified pedestrian environment through the provision of more generous pavements and street trees.
You know
Policy aimed at delivering a series of coordinated streetscape public realm improvements. And I think if we're delivering the benefits that we are, I'd struggle to see why, when we're trying to achieve exactly what the policy is asking us to achieve, it is an opportunity area that is anything other than considerable.
Well, you do understand why the council doesn't give it the same way they do, is because the council's recognising all the competing pressures placed on that space and therefore doesn't in fact consider that the comfortable and simplified pedestrian areas, etc., that the policy was seeking has in fact been achieved.
Well, the council's position was they prefer the existing site in public realms.
I think you need to be a bit careful, because it's not the purpose of the inquiry to have sort of caricatures. What the witness said was that in light of all of the townscape impacts of the appeal scheme, the status quo was to be preferred. Now that is not an unreasonable conclusion, bearing in mind her concerns about the scheme.
Mr. Connell, in his rebuttal, describes public realm as negative. His weighting is negative.
Yes, and hence, because he isn't he, relying upon the townscape expert evidence, which has pointed to a series of conflicts and competing pressures on that Hills Road side of the development.
Well, I think a policy that's actively trying to encourage public realm improvements of the type that the status quo would be preferable, I think is not in accordance with what the policy. But the point I'm making, Ms. Murphy, is that I think considerable is exactly the right weight to attach to.
Yeah, and again, the situation which faces the Inspector of Courts is that the judgment has got to be, which townscape evidence does he prefer and place more weight on? And your judgment about the weight within.
I agree with that. But he has to have regard.
Sorry, do you mind if I just finish? It's similarly dependent, isn't it?
Yeah, I agree with that. As the planner, though, I'm saying through the prism of policy 25, sir, that you need to look at what 25 you need to look at what policy 25 is seeking to achieve.
And so there is then a primary balance then really is the delivery of offices in a sustainable building really versus the harm arising to the historic environment. And on one analysis, it really comes down to that. And when thinking about that, you've got to recognise, haven't you, that the Botanic Garden, it really is, it's at a more human level, it's a much loved part of Cambridge, and what harms that much loved part of Cambridge is really ought to give pause for thought.
Yeah, well, I actually explicitly referred to the improvements in relationship to the Botanic Gardens in my list. I tried this morning, sir, to try and put it into one rather than slice and dice, as I thought it might be more convenient with Ms. Koski in chief just to bundle these into one heading, but it might be helpful if you feel that we need to go through them. But I think the improvements to the Botanic Gardens, which I identify here, are moderate benefits.
So then I put to Professor Taverner that it was open to the inspector as a matter of planning judgment to refuse planning permission on appeal and await a scheme of a different design which causes less harm if he concludes that the scheme does cause harm. Now, do you accept that too? I should think, do you? It's open to him.
Quite a lengthy discussion this morning on that, but if the inspector takes the view that the fallback position, then he might, which is not my case, then he might come to that conclusion.
Forgive me, I wasn't actually necessarily talking about the fallback. I'll put the question again so that you can just have a mull on it. I put to Professor Taverner and he accepted, but would like to have your evidence on this too. that it's open to the inspector as a matter of planning judgment. If he finds that harm arises as a result of the appeal scheme, it's open to him to refuse planning permission and await a scheme which causes less harm. It's open to him to do that, isn't it?
Well, I've made it clear that that's not my position.
I know it's not your position. I know it's not your position. You don't want him to do that, but it is open to him as a matter of planning judgment to conclude that, isn't it?
Not on the basis of my evidence. On your evidence, he may take that, but not on the basis of the appellant's made.
Oh, yes, okay, I see. If you were to accept Historic England, Mr. Griffiths, the council's conservation area, that heritage harm arises at a less than substantial level, moderate. If he were to conclude that, contrary to your case now, it would be open to him to conclude, wouldn't it, that the appeal scheme should be dismissed, and the better course is to await a scheme which causes less harm.
There isn't an alternative scheme. That isn't before the inspector. We aren't here rationing up planning permissions. The inspector is here to determine the scheme that's in front of him. If he deems it's harmful, then he'll refuse it. But we're not asking him to compare it. We're asking him to compare it to the condition on the site now, not an alternative scheme.
Well, I've been just trying to work out quite what your case is on this, because we'd understood that, and I think on the basis of the information we had, it was the right conclusion, but there we go. That the intention was to build out the extant scheme in the absence of planning permission here. And if that's not right, what you're telling the inspector, as I've understood your evidence in chief, is, well, if we get a decision and the inspector finds there's heritage harm, we'll go back to the drawing board. So I'm asking you whether, as a matter of planning judgment, bearing in mind your evidence earlier, if he finds heritage harm, for example, or other harm, he could, as a matter of planning judgment, say, well, I'm going to refuse the scheme and await another scheme which doesn't give rise to that same level of harm.
Yeah, he can't wait for that. He can refuse it on the basis of harm. If the inspector feels there's harm from the scheme, he can refuse it.
Okay. You think, as a matter of principle, he can't do that?
Well, there isn't another scheme in front of him that we put forward. We are asking him to compare the benefit that we're going through now against the position on the site as it is.
Okay, all right. Well, that is a submission point then. Good. Well, thank you very much indeed, Mr. Derbyshire. Those are all the questions that I have for you in cross-examination. So those are all my questions.
Thank you, Ms. Murphy. Thank you, Mr. Derbyshire. That was a lengthy and sort of thorough cross-examination, I think, by any standard, and it's exhausted any questions that I would have put, quite frankly. But there could be some questions from interested parties. Mr. Koletsky has indicated that he would like to put some questions to you.
He did.
And so you're aware of that. So
I think I was put in the line yesterday, I think, so I was on side about.
Of course you were.
Yeah, I was, yeah.
Yes, of course, I'd forgotten. So if Mr. Koletsky could turn his camera on.
Okay, I have been unable to do that. I am unable to do that now.
Oh, you're there.
Yeah,
You're there.
I'm there. Right. Hello. Thank you for giving me the time to do this. I will try to be short. Just to introduce myself and my interest in the scheme.
Can yes. Whilst I always enjoy seeing Fiona on Zoom, she might not be aware that she's visible on the call.
Oh,
apologies. Okay.
Are we fixed now?
We are fixed, yeah.
Right. Okay. I'm a very close neighbour of the proposed scheme. I live in Vinter Terrace, which is in the triangle, which is sort of part of CB1, just behind the first terrace of 19.
I have met you many times, Mr. Koletsky, at public consultations events. You are very good, so I do remember the name.
Thank you. And the other thing is, I just wanted to mention that I have been concerned before I retired. I worked in science and technology for a long time in the computing side of that. So that's the background to my questions. So the first one, I think we would all probably agree, and this is because you rely to some extent on Mr. Wise's evidence of the market, that markets are not infallible. They have bubbles, they have slumps, and so on. So they do sometimes make bad decisions. And one of the reasons for the entire planning system to be there is to try and avoid the possible harm that those decisions have. And I was wondering if that those very market-based decisions have. I was wondering whether you'd agree with that.
Markets do go up and down, Mr. Koletsky. CB1 has gone through one major credit crunch and has gone through the COVID, and it is probably stronger than it's ever been.
Right. The other one is also, I think it's to do with Mr. Wise's evidence, which you kind of incorporated by implication. And that is the building itself presents very green credentials, but only, as I understand it, once it's in operation and running, and only until it finishes operation. As far as I understand, the entire life cycle of the building and of any buildings which it makes obsolete and therefore demolished has not been taken into account. And particularly the use of concrete, which can generate a lot of CO2 in its production and also at the end of its life, as far as I understand, has not been considered. Is that correct?
For a number of reasons, Ms. Koletsky, we are not retaining, good reasons, we are not retaining Francis House within the scheme for a number of related reasons for the scheme.
But I'm not talking just of Francis House. I'm talking about places which possibly compete with as office space providers with the projected building, places like One Hills Road, Sintra House, which is undergoing renovation, like those.
Yeah, One Hills Road isn't available, as you're aware. It's the university. I think that's the building, the old Cambridge Assessment site you're talking about, Ms. Koletsky. Yes. That's owned by the university, and that's dealt with in Mr. Wise's evidence. Sintra House, as you're aware, has not been very productive over the last few years. The owner has boarded it up and hasn't been particularly quick in bringing it to the market. And I'm not absolutely sure that I'm aware of the point you're trying to make in answering those questions. Put it to me again, and I'll try the best that I can to answer your question.
I'm just trying to show that the life cycle costs of the building, of building it and having it there, also given that it's the life of commercial buildings like that tends to be shorter than those of residential buildings, as far as I know. But all of that does not discredit or diminish the green credentials that you've claimed.
I don't know if you saw the scheme architect's presentation on the first day of the inquiry, but it's a health presentation that the inspector, it is on the inquiry documents if you want to see it. And within it, I think it's figure 4.3 is the performance of the building against a number of criteria: water consumption, energy. So you can see that we have built in that life cycle discussion from day one. And part of that is to get us to the BREEAM outstanding designation.
All right, I'll review that. Thank you very much.
Please do.
Yeah. The next one is, the next question is, it's to do with my question to Mr. Wise a day or so ago, is it seems to me that the building has been, your ambition is to be an extremely high quality building, but it seems to me from the plans that it's going to be mostly open plan
You said it.
And there's going to be a very large amount of food and beverage space reserved for that purpose, presumably to have people socialize and interact. The question I would like you to reconsider in the light of current developments in science and technology, and in the light of my experience where I found open plan to be extremely unproductive as against individual offices with socialization spaces, whether you will still regard that as a high quality solution.
Yeah, I would call you a computer scientist, weren't you? I think.
Yeah.
I was hoping when you said about your background, you weren't going to ask me those questions, but it seems we're on territory that I can deal with, Ms. Koletsky. I can't really add to Mr. Wise is our market expert, i.e., he provides what the market wants. So when tenants come in, and I will use the Microsoft example, they come from West Cambridge, as you're aware, they were very much whiteboards with their artificial intelligence, and they wanted a slightly different arrangement in the building. So I think the building's adaptable to the type of people that come in and what they want to do. So it's an eminently adaptable building, whether it's a computer scientist who loves his little hole and his whiteboard, Mr. Koletsky, or whether it's someone a little bit more the Amazon Alexa research or the Samsung AI research. So there's a world of opportunities for people.
I see. So is there a plan for there to be, as there seems to be over Botanic House, a crane to lift heavy equipment, like maybe heavy equipment needed for further advances in quantum computing? Will there be cranes like that on top of these proposed buildings?
It's not our intent. You are delving into areas that I don't know, but it's not our intention to do that. It's not our intention, but I can't claim to have any expertise in that area.
Okay, thank you. As we're speaking about Botanic House, you were talking about clusters, specialized clusters of science and technology. Who is the main tenant in Botanic House at the moment?
It is, scientists do need lawyers, you know, so it's Mills and Reeves, and you'll be pleased to know Hawley, one of the leading sustainability engineers, are on the ground floor. So and another firm of accountants. But you will find down CB1. This is the beauty of a cluster. You get the brains, and then you get the people that want to make money from their brains, Mr. Koletsky. That's how clusters work.
I see. So quite apart from science and tech, we're talking about the possibility of having venture capital in there, things like that.
It's not for me to say the telling. We call it knowledge economy. So it is. But if you look down CB1, you've got all the billion-dollar companies that I've talked about, but you have a number of lawyers as well. And as there are two lawyers on this call, I think you need to be very careful what you say, Mr. Koletsky.
Oh, I didn't mean any disrespect to them or anything like that. Although I would commiserate with those of them who have to work in open plan offices. But changing the subject and going slightly west from Botanic House into the gardens themselves, the inspector will, of course, see for himself on his visit. But one point that has been missed in the evidence I've heard so far, and I've heard most of it, is that the Botanic Gardens, with their role of a working plant sciences laboratory and the role as a plant museum and a tourist, if you like, a tourist attraction, also fulfill another very important role. And that is, for people like myself who live in the cluster, it's our nearest open space of any significance. I mean, there are tiny little bits of green in the triangle, but of any significance, it's our nearest open space, a season ticket to the Botanic Gardens, which for friendship is quite inexpensive. A lot of us have it. I have it. So just given its mixed use, it's not all peace and quiet. There are people around doing exercise, doing jogging, running, and so on. And I just would ask whether you would agree with that point. It's not a pure rest and serenity type of place.
No, I think it was conceded. It is a working laboratory. No, you're quite right. It has another function. It is one resource.
Yeah, it has several functions, such as a recreation space for local residents.
Yeah.
Yeah, and the 3,000 people that are supposed to work in the new building, given that season tickets are quite inexpensive, may well buy them and put quite a bit of pressure on that place on workday lunchtimes, for example.
Yeah, I don't think the footfall would. There's been no case made to the inquiry. You're making the point. I don't think the level of footfall would. The Botanic Gardens haven't objected to that, nor have the university to that. And ultimately, they're the custodians and they look after the gardens on behalf of the university and the city.
All right. Well, that really is all I have to say at this point. Thank you very much, Mr. Derbyshire.
Pleasure to see you again.
Thank you. Same here. Thank you.
Okay, I see no further hands up, so I will pass over to Mr. Katkowski to put further questions he wishes.
Thank you, sir. Thank you very much indeed. Mr. Derbyshire, I thought for one moment you were going to say you get the brains and then you get the lawyers, but you managed to stop yourself saying that. Reminds me of Wat Tyler in the Peasants' Revolt. The Peasants' Revolt slogan was "Burn the lawyers." So there you are. Right. Anyway, can we get down to some re-examination, please? Now, so I'm just going to. This is addressed to the inspectors. I'm just going to ask you a question, sir, if I might, which is that in the at various stages during the course of the inquiry, and of course several stages to my own friends' questions to Mr. Derbyshire, reference has been made to an email from Mr. Bainbridge to an officer at the council in November of last year. To the best of my understanding, that email or the exchange of emails, because there's an email to us and then there's Mr. Bainbridge's response. I don't think that's actually before you, so I don't think you've actually got to hand the, if you wanted to look at it, the exchange. So if that's right, and I think it is, and last time I said something like this, Ms. Murphy corrected me, but I think I'm right on this occasion. If that's so, then it seems pretty obvious to me that you should have the exchange of emails. Otherwise, we're going to be in a bit of a pickle, I think, because all sorts of things have been said, and you haven't actually got the document that you're referring to.
Logical, Ms. Murphy, you continue.
I put the relevant wording from the email into my openings.
You did.
You
did, but it's surrounded by other words. So the inspector
finish what I was saying. I've got no difficulty at all with that going in. It isn't in at the moment, and yes, I think you should have it.
Okay.
Fine. If that could, if someone could add that to the inquiry documents, that would be most helpful.
Indeed, and to be fair, there was an email to us. I think from memory, there's an email to us from the council, and Mr. Bainbridge's email is a reply to that. So, we obviously need to put both in just so the full context is there. Good, thank you very much indeed. That's excellent. I'll ask Mr. Bainbridge to liaise with his opposite number at the city to ensure that's done. Thank you very much indeed. Right, so some questions just for you, Mr. Derbyshire. And we're going to start with a subject that I'm very glad this is our last turnaround in evidence on this point, but the extant consent. And I wonder if you could just take the University of Cambridge's letter to hand. Do you remember you were referred to it in your I'm an only friend course of cross-examination? It's core document 3.10, I think. Is it?
Cambridge University, 20th of the 9th.
No, wait a minute, that's not right, is it? Hold on. Let me get this. Make sure I've got, because I've got a hard copy. I'm just going to check. I've given you that. Bear with me for one moment. Hold on a moment.
What are we looking for? The representation from
University of Cambridge.
University of Cambridge, it's 3
I've got it up as
310.
310. Yeah.
310, yeah. That's what I thought it was, yeah, sorry. I just had a momentary wobble there, forgive me. And I wonder whether when you've got that, do you have it there, Mr. Derbyshire?
Okay. The letter of the 11th September 2020.
That's right, the 11th September 2020. That's the one. Do you remember you were taken to the second page of it?
Yeah.
Okay. And do you see there's a heading there, scale, massing and impact on setting of the Botanic Garden? Have you got that? You do, good. And can we just look together at the first paragraph under heading, which starts with the word first? Do you see it
Yes.
there?
Yes.
First, we note that the applicant argues that the assessment on the Botanic Garden shows that this scheme, as we know is the appeal scheme, presents less harm to the garden than the extant scheme, which could still be implemented, etc. Is the university's understanding of the point similar to, different, same as your understanding of the point?
Yeah, the wording is the same. In chief, I use the word could, not would.
Exactly. And when you gave your evidence in chief, when you used the word could rather than would about the extant scheme, bearing in mind your obligation to the inspector, to the tribunal, is that evidence that you gave off the top of your head, if you like, or did you make any efforts to ensure that you gave the position correctly to the inspector?
I had to ensure that what I said was fair and reasonable and that I'd taken instructions on it.
Thank you very much indeed. Now, my learned friend asked you about Mr. Bainbridge's email, which the inspector's going to have a copy of. Do you remember from November of last year, and those discussions that were taking place about the statement of common ground? And just tell me this, she put to you that Mr. Bainbridge would have taken instructions or confirmed the position before writing the email, and you said that he would have done so. Do you recall that?
I do.
Yeah. Do you know that as a matter of fact?
I made an assumption.
Thank you. Good. Can we move on, please? And to something completely different, if I might. And that's as follows. I'm going to jump a long way now, and I want to go to a completely different subject, which is the reason for the local plan review. I'm just going to track a few points together with you, covering some of the ground my own friend covered. So to understand why the local plan is being reviewed, can we actually go to the existing local plan itself, because it has actually got a policy on this subject. So that's core document 5.1. Tell me when you've got it.
I've got it.
Thank you. And you will need, I think the inspector's got a hard copy of this. So it's original page 41, it's electronic page 48. And I know what you're using, Mr.
Both.
You're using both.
I'm going electronic. So you said page 48 electronically.
Yes, and 41 original.
Yes, I've got that. Review the local plan.
Thank you. And have you got there? That's right. Have you got the review of the local plan? Thank you very much indeed. And do we see there? Well, I mean, it's all written out on the page. We'll undertake an early review, policy 9. Specific matters to be addressed, and is this where we find out why the plans be reviewed? An updated assessment of housing needs, progress being made towards implementation of the spatial strategy for Greater Cambridge, including new settlements, and then where are we? This is the point about travellers, I think, isn't it? The third point, yeah. So is that, without beating about the bush, is that why we've got a local plan review on hand now, because of the reasons set out in that policy?
That's my understanding.
Yeah, all right, thank you very much indeed. Now, in terms of the local plan review itself, can we go now to the local plan review, to core document 5.12? Yeah.
Yeah, sorry. Sorry.
That's all right, don't worry.
This one I think I've, yeah. first proposals.
The Reg 18 plan, that's the Regulation 18 consultation. Is that the document you've got there? 5.12?
Let me get it rather than.
Oh yes, please do get it.
Sorry.
Otherwise, there's going to be much confusion.
No, it was the document I had. Sorry, I just wanted to double check.
That's right. So it's a Reg 18 plan.
Yeah.
And if you go to electronic page 59, that's where you'll get to the start of a section about areas of major change. All right. Yeah.
I've got it.
Thank you. So that's on page 59 and it continues over the page to page 60. So can you just open page 60, electronic page 60?
Yeah.
All right. Now, just listen along, Mr. Darb. So the way my learned friend, if I might say very fairly put it, was that the council's position is in the existing local plan, the allocation of our site sets out requirements, for offices, for residential and for a mix of air uses, all right? So they're requirements. And the council has carried over that allocation in this Reg 18 plan, all right?
Yeah.
That's the position, and it's very clear from the text. And they have indeed carried whatever the policy means in the local plan. They've carried it over into this new local plan document. Yeah. That's what's happened here. So let's just accept that. What I'm interested in is if you look at page 60. Remember, this is a Regulation 18 plan. Can you just go to the bottom of electronic page 60, and do you find a heading there? What consultation have we done on this issue?
Yeah.
And what's it say?
There were no specific consultations on this issue.
Right.
The first consultation draft.
Okay. So no consult, because this is a Reg 18 plan. So there's no advanced consultation on whether that's the right thing to do or the wrong thing to do. It should just carry over these areas that need to change. So you, actually on behalf of your clients, see this in the emerging local plan. They're having been not complaining, but no prior consultation about it. What then happens? You said earlier on, you asked me on 3 occasions. I think you go on.
Sorry, Mr. Kukowski. We object to the scheme.
Yeah, and what is the gist of those objections, representations?
The compelling need for improvement floor space, the benefits, the economic benefits to the area, and the removal of the residential element for the avoidance of doubt in a mixed-use development.
Yep. All right. Thank you very much indeed. Good. That's grand. And then in that context, without retrieving the document again, although we can if we need to, do you recall that in evidence in chief and indeed in cross-examination, the trajectory was referred to, the housing matters, you'll recall. And as you explained in your evidence in chief, when we saw the passage, the council says it hasn't included the site for the reasons which are explained in the trajectory, its trajectory through to 2041, as we've seen.
Yeah.
Yeah. So can I just understand this as a matter of fact? Let's just assume that the council in its Regulation 18 first consultation new plan wishes the appeal site to continue to be earmarked, if you like, not only for offices but for residential as well. Let's just assume that. Let's just assume that's exactly what's meant. That said, when you actually look at the background material, does the council actually need the site in order to make up its numbers for the period of time that it's dealing with all the way through to 2041?
It's made no provision at all in the trajectory at all.
Yeah. All right. Thank you. Good. Fine. Can we now move to a totally different subject? We're almost there, and that is that. We might have been getting ourselves a bit confused about policy 61 in the local plan. So this is about heritage now. So this is just something completely different. And you very kindly, very helpfully set the policy out at page 27 of your proof. Just to save us using these blessed electronic documents anymore. And you tell me when you're there, Mr.
I have it, Mr. Kukowski.
Great, thank you very much indeed. So I'm just trying to understand just trying to understand what you're saying here. So policy 61, we've got an item A that one should preserve, and we know that means, not harm.
Yeah.
So not harm the significance of heritage assets. My learned friend's point is that depending on what evidence the inspector accepts, even if it says Professor Tavern's evidence, he's going to find some harm to heritage assets. Yeah. Point being put is, well, look, that's a breach of the policy, isn't it? And you referred repeatedly in your answers to item E, which tells us that one should provide clear justification and look to see whether there are substantial public benefits, etc., etc. So just help us, please. What's your understanding of the policy? What are you doing? Are you stopping at item A, or are you inviting the inspector to do something else? How do you approach this policy?
Well, I obviously, I was hoping I was clear. What I'm saying is the balancing exercise is helpfully done through the prism of this policy. So if the inspector finds the benefits outweigh the harm, then we are policy compliant. That was my point. That Miss Murphy was trying to say that any harm to the conservation area asset, as night follows day, is therefore in conflict with the local plan. That's not our position. Right. As I'm clearly.
Good, got it. Thank you very much indeed. Right, so those are the questions I had. There are just two other points that I just want to. Well, one that I want to raise with the inspector, and then another which I just want to say something about. So the first of those points, thank you, Mr. Derbyshire. The first of these points there is that reference was made to the opening hours and the botanic gardens not being used in the evenings, etc. And I wonder, sir, whether you would mind if we, Mr. Derbyshire's gone, if we and the City Council could just agree, I think it's just going to be copying pages off the Botanic Gardens website to put in an inquiry document, because the position is that there are opening hours for the garden, but there are actually some events. I'm not saying there are lots, but there are some events in the evenings held in the garden. I think you should just have the factual position set out so that you understand it correctly. Is that all right, sir? Without making sure approval?
That's perfectly acceptable, and I think Miss Murphy was nodding.
Yeah, we're not going to put any commentary on anything, just put in the pages from the website, and then it's nice and easy. So I'll just, through the medium of this, hoping that Mr. Bainbridge is still listening, I'm sure he is, through the medium of this electronic age, if that could just be put on a to-do list, please, if you can just agree with the relevant officer at the City Council, which bits of the website we're going to put in. Thanks, thank you. That's that. And so the other thing is, I thought it would just help thinking ahead to next week and the closings on Wednesday. And obviously, my learned friend is going to close her case before I close mine. And I think it might just help if and this isn't a private matter just between myself and my learned friend, because obviously it affects you and you making your decision, and obviously anyone else in public who are listening to this. So I thought it might just help if I just made my position crystal clear on a point of law about the material, about the extant consent, just so that my learned friend has it. And it's no different from the way in which I put the point to Mr. Griffiths when I fairly early on in my cross-examination. But just to be crystal clear, I just want to explain now that what I would be saying in closing, so this is an advanced preview, is that there are two separate questions. They are to an extent related, but they're also distinct about the extant consent. One is it a material consideration? And the other is, if so, how much weight should be given to it? And the two things should not be conflated. Now, as to the first of those, whether the extant consent is a material consideration, I think it's agreed by everyone it is, but I just want to be crystal clear. Whether it is or it isn't a material consideration does not depend at all, in my submission, on the degree of likelihood of the permission being built out, should this appeal be dismissed. So it's a material consideration, come what may, is my point. This is my first submission, if you like. And my second submission then, so my second point, is in relation to the weight to be given to the extant consent as a material consideration, as I put to Mr. Griffiths, and as I freely accept and acknowledge, the degree of weight that should be attached to the extant consent, the courts have held in a series of cases that it's lawful to gauge the degree of weight that you attach to an extant consent as a material consideration by reference to the degree of likelihood of that consent being built out in the future. So I just want to make that crystal clear.
It sounds like a rehearsal of submissions.
Well, that's what I said. That's why I said this is, forgive me, Ms. Murphy, this is because I'm closing after you. It is a rehearsal of submissions. I'm just saying, in fairness to you, but it's not just
what it's doing is effectively getting your point in now, isn't it, Mr. Kekowski?
Good heavens, can't I actually be fair to you?
That's
the reason I'm doing it.
I mean, what it's doing is it's rehearsing closing submissions beforehand. I'm quite happy to deal with all of these points in closing submissions in the ordinary way.
Okay, well, I'm a little bit surprised at your attitude, but there you are. I was actually trying to be fair.
So,
but that's fine. That's absolutely fine.
I'm a little bit surprised to have those submissions made at this stage without notice and no expectation that I would reply.
Okay, well, I've heard what Mr. Kapkowski has said. I'll close it there. Whatever discussions you have together privately is between you, but
I'm not intending to have any discussions privately, but sir, thank you. The only other matter we need to discuss before you do close the inquiry is contingency arrangements for next week.
yes, who's going to cover on? Do you want me to lead on that?
Well, I don't know. So I mean, basically, as I understand it, we've got the inquiry venue booked.
Yep.
I imagine we're all planning to be there on Tuesday mornings. We've got willing and everything.
Yes.
I'm just seeking to explore. I mean, should something happen to one or other of us,
absolutely.
What is the contingency? Because
my position is that inquiries are hosted now by the council.
Mm-hmm.
Previously, PINS hosted them virtually through different platform, but we've passed that back to the council, and so we've always made it, as this pandemic has ebbed and flowed, if you like, we've made councils aware that they should have contingency planned, really. So in a sense, I'm reliant on the council to be alert to this possibility, and I don't know if Miss Bradley is able, who's been helping sort of behind the scenes, whether Miss Bradley is able to put a camera on to.
I mean, I wonder.
Miss Murphy might be able.
Yeah,
to.
It won't. I don't think it'll be the final word on the subject, but I suppose the working assumption that we make is that everybody will be taking a lateral flow test before they turn up, and if somebody's lateral flow test unfortunately and unexpectedly turns positive at any stage between now and then,
luckily
everybody will be told. And so the working assumption that I've made is that there'll have to be some sort of hybrid element to cater for that, because of course nobody wants that, but it could happen.
That's the point.
Yeah,
that's what I was trying to get to the bottom of. So although you're right, so that the onus, if you like, for running these events in inverted commas is now placed on the council. In fact, in these circumstances, kind of we're running this part of it because we're the ones who have booked the room at the hotel, etc. Yeah. And I know, because I've asked about this, that there is a facility to have people on, a webinar type facility as part of that package. Mr. Derbyshire tells me he's attended sort of webinars sort of in the very suite that we're talking about. So there is that facility, as I understand it, which I think will cover the point that my only friend has just made, the hybrid point my only friend has just made. Well,
we can only approach it as and hope for the best.
Exactly.
PINS has announced that we're moving back to face-to-face events. So as far as this organisation, if you like, is concerned, we're good to go. There's always this risk element. You mentioned lateral flow tests. I've just had a delivery of them, so luckily I've got them because I believe they are rather scarce at the moment. So, and you've told me that the venue, the hotel, has got some sort of capacity for virtual engagement as well. So
I understand it, sir. I'll make sure that's the case. Yeah.
Good. So I think the only thing from my point of view is when I travel up to Cambridge and when I meet for the site visit, and whether it is on Monday or whether, as I hinted, it could be
Yes, could you just
Tuesday.
one
Let's
moment?
bottom that out before we close.
Indeed, there have been.
Please, we for our part, we're quite happy to do it on the Tuesday, sir, if that might suit you a bit better.
I think it would help me. It means I don't have to, I've got Sunday to myself.
Yes, exactly.
Yeah.
Yes, no, so we have, there have been lots of emails flashing around, and so I'm just checking the latest position. Forgive me for one moment.
Yeah.
So, sadly, from our perspective, and I'm ever so sorry to be the spanner in the works, but Professor Taverner had rearranged his diary to be there for the Monday, and he can't now do the Tuesday. And there have been lots of emails backwards and forwards, and he's confirmed he's had a go, but he's confirmed he can't. I'm afraid. So I'm ever so sorry, sir, but I think we're stuck with Monday.
Yeah. Well, in a sense, I suppose it was my fault for going for Monday originally,
Sorry.
and then thinking about it. But in which case, and I'm assuming then the council are okay for Monday, although they would have done Tuesday. And
Quite happy either way. Whatever suits you, sir, is fine. If we could possibly have it at lunchtime on the Monday, as I think we were originally aiming for, then that would be useful, because it would mean that, for example, Mr. Griffiths, he's going to be travelling on Monday morning.
Yeah, if we could have it lunchtime. I mean, the nights are gradually moving out a little bit, aren't we? Well, I don't know how long it's going to take, an hour or a couple of hours. So should we agree on a time on Monday? We're going to meet as per the itinerary at the site and then follow the lines. So should we say 12 noon, or is that?
I thought so. Mr. Bainbridge is just WhatsApping me, and apparently I thought at 12:30 had been agreed, but sorry, not me.
I'm
I thought
a few emails with my assistants not working today.
Because I think so, if I recall this correctly, because I was obviously concerned that you must, accompanied, obviously, you must go and see inside the Flying Pig. And I think we're starting, not we, you and those who would be attending are starting at the Flying Pig, as I understand it. I think that the idea is that should be at 12:30, but Mr. Bainbridge, who I know is listening to this, if Mr. Bainbridge could just send me a message to confirm, and that is right, he's telling me. So 12:30 at the Flying Pig. So
Monday, 12:30 at the Flying Pig.
Yes, that's right.
Isn't open, but we'll be going in.
But it will be.
But not to have a drink.
Not to have a drink, so.
No.
Just bring your own bottle. It's a bring your own bottle party. So, but I think there might be an echo of someone there.
Okay, that's good, and that'll be Monday. So I might cancel my Sunday night in the hotel and then get the train up in the morning. That's excellent.
Right.
Okay, and as far as personnel, I'll be meeting Mr. Bainbridge and.
No, it's Professor Taverner, Professor Taverner, and it's going to also be, just bear with me for one moment, hold on, this is coming through, and it's also going to be Mr. Alford's assistant. You recall he was in on the Flying Pig roundtable session the other day.
I'm sorry to be awkward, but could we possibly have it at 1 o'clock? Because I understand that
Fine.
the earliest we can. I'm so sorry, but the earliest we can manage it is 1 o'clock on Monday, and it's going to be Mr. Griffiths and Miss Bradley. I know that half an hour is not going to make much difference, but it would help for various.
That's fine. That's absolutely fine. Not a problem at all. Ironically, that was Professor Taverner's original suggestion, but it doesn't matter. 1 o'clock is absolutely fine. 1 o'clock is
that's fine. Changed to 1 p.m. on site. I don't need to. I'll see that there'll be a collection of people there. I
think there'll be two.
I know some of the faces, obviously. Right. Okay. I'm just trying to think of it. And then the inquiry on Tuesday starts at 9:30 still. So we know the venue. So we all bowl up there. I'll be staying in the hotel anyway. So I will see you face to face then. I'm just checking there's no other housekeeping points to raise. I'd just like to thank the council for the work on the Zoom meeting, which I think despite my best endeavours to wreck it on day one, has worked pretty well. And also to the appellants for the website, which is, again, I think we've been dashing in and out of that, and it's worked very well. And of course, to your good selves in your keeping the show admirably on the road. So look forward to seeing colleagues on Monday at 1 p.m. at the Flying Pig and doing the walk round. And thank you for your work today, and we'll see you on Tuesday. So I will adjourn the virtual inquiry now, and we will resume the physical inquiry at 9:30 face-to-face in the Claydon Hotel on Station Road. Okay.
Thank you very much indeed, sir.
Thank you both, and have a pleasant weekend.
And you, sir.